together as we initiate chaos theory guarantees that we'll play like lightning shots sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only wakes us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All above the petty express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the petty express. In a beautiful darkness.
Well, hi, you guys, and welcome back. Now, if you are not aware of the Shanda Vander Ark case, it is a trial that we've covered. It is, in fact, one that I kind of wanted to go back to, at least with the body cam and interrogations. But it's also a very, very incredibly hard trial. This woman that calls herself a mother systematically basically starved her special needs child, her 15-year-old, until he looked like something from a time period that history should not forget. And it was incredibly hard. Shanda did testify in her own defense. Shanda was, in fact, uniquely qualified to testify in her own defense, considering that she had passed not only the LSTATs on her first try, but the bar exam on her first try. So she was not without the mental capacity to realize that systematic refusing of her son of food would lead to terrible consequences. Now, her defense at trial was that she was simply overwhelmed and suffering from her own mental health issues that basically caused her to black out anytime she would be under stress. Now, the jury and no one bought that. But Miss Vander Ark believes that she was treated unfairly. Now, I believe that this is going to be an ineffective, you know, assistance of counsel. Basically, Shanda has contended that when she got sick while testifying, she did not want to basically discontinue testifying. She wanted to continue testifying after a brief period, but she claims that her lawyer, without consulting her, basically, forfeited her rights to continue to testify. Now, I think she was just god awful terrible on stand and realized that no one was buying anything that this heifer was saying. But it does look like she has a new appellate attorney who is doing his darndest to make sure that all of her due process rights were faithfully taken care of. I find that I'm having trouble giving a damn in either case. Ichabod Crane apparently survived his run-in with the Headless Horseman to defend Shanda Vander Ark. His life did not get better just because he didn't get attacked. And look, this is basically gonna be a roast, y'all. I have nothing appropriate to say. I love the fact that she's having to write with, like, her arms all uh, the fact that they didn't give her the inside of the pen nubbin pisses me off. I feel like she should be given the pen nubbin Daryl Brooks treatment as well. In case you're new, this is the Petty Express. We will be making all the fun of Shanda Vander Doof over here. At least she isn't dressed up like Satan's Land O'Lakes butter girl this time.
I think it went every time we go back upstairs.
I can't tell if someone, allegedly with prison justice dotted her I, or that is just like her bags have eye bags. I mean, because here's, like, the anatomic where, like, the original eye bag would happen, and then she has an additional, like, echoing ripple of eye bag. It's official. Her face is trying to run away from her, and I'm quite frankly on the face's side. "Run, face, run!" She had 2 braids during her trial, so she looked like a satanic Land Lakes butter girl, is all I could figure. Now, I have heard, part of the reason I wanna watch this is I want to be part of making sure that this monster never leaves the prison, but also, I have heard that the state prosecutors go ham on her, and I am here for it. JKD Buck, I'd pay for someone to set her alight. Me too. I mean, we need to know if fire suppression by, stomping works, allegedly in Minecraft.
Circuit Court, County of Muskegon is now in session. The Honorable Matthew R. Case will preside. Please be seated. Good morning.
And I like this judge. If you watch the trial with me, I very much thought this judge was incredibly sensitive to, making sure that pictures were not shown of Timothy, especially, some of the crime scene photos. It wasn't until I had gone to some other true crime streams that I saw some of the pictures, and this judge was incredibly protective of Timothy, didn't want those pictures to be, internet fodder, and I just found him to be incredibly respectful and very, very, very touched by this case, and you don't always get that during sentencings, but this judge, it seemed like he really wanted to protect Timothy however he could.
All right, before the court is file 23110FC. It's people of the state of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark? All right, Ms. Vander Ark appears before the court with her attorney, Mr. Ambrose, Mr. Roberts, as well as Ms. Bloomquist are here on behalf of the people of the state of Michigan. Date and time, the court is scheduled for a Ginther hearing, and technically a continued hearing from the last time we were here. We're delayed. There's been some concerns regarding Ms. Vander Ark's health this morning. Mr. Ambrose, if you want to go ahead and make a record of any concerns.
Did health ma'am, I could care less about your health. I You're lucky I'm not the judge in this case. I'd have called you Shander Vander Dipshit. Like, I would call you everything but what your name is under as a child of God, okay? And, oh, you could have been dying of leprosy, and I would have had them cart in your falling parts in a tote. Like, you weren't gonna get out of this hearing, so you're very lucky that Hagrid, Robbie Coltrane, has decided to be your judge and not Mo.
You have at this time.
Yes, Your Honor. I had a video conference with Ms. Vander Ark on Friday, this past Friday. It was concerning to me because she didn't appear to be her normal self, and so that concerned me.
What, a ginormous gold-plated bitch? I mean, how can you tell, honestly? The woman systematically enjoyed, calculated, watched, and I do mean watched, studied the torture of her son. I really don't care whether she seems like her normal self or not.
So I did send an email to the court expressing an adjournment if possible, just because this is an important phase in the whole appellate process, and certainly of utmost importance to my client that she's able to participate in a meaningful manner. And during our conversation on Friday, it just didn't seem that she was as up to speed or healthy. She expressed some health concerns that she was undergoing at that time. And
You know what? She didn't give a rat's ass about her son's health concerns. I really don't care whether she has the yeast infection from hell or just an ingrown toenail. In fact, I kind of actively hope she has both concurrently at the same time, along with a really hard to reach but very infected pimple somewhere. So don't really care.
so that's why I asked for an adjournment on Friday. What I understand is that what she told me this morning is on Saturday, she had an episode at the Huron Valley Women's Facility where she passed out for a short period of time, was revived, but, she had a medical issue at that time. She's not feeling well today either. I know she was checked out by medical. Her blood pressure is higher than it is normally for her, as she self-reports.
Now,
So I would
pointing out, this is her former attorney, the man that she is claiming screwed her over in her first trial. Guessing he doesn't also give a rat's ass whether she's feeling, bright-eyed and bushy-tailed today either.
be requesting an adjournment. It doesn't hurt the prosecution, I don't think, at all. It is, if anything, delaying this case keeps her in prison. I'd like to move forward if I could, knowing in good conscience that we're putting our best foot forward on a case like this, and have the 100% confidence that my client is able to participate in a meaningful manner. And I just don't think at this point I can, with any type of confidence, say that. So I would still ask for an adjournment. And I know that my client has signed a release for some medical records from Huron Valley Women's Facility to release at least the most recent episode that she had.
Okay, Mr. Ambrose, is she able to speak to you this morning?
Yes.
Not getting into what those conversations are, but are you able to converse with her this morning?
I can.
The judge is like, she can talk. Can she talk at you? If it was Indiana, it'd be like, are you able to talk at your lawyer? Yes, ma'am, I can conversate with him. Oh, so you all are able to conversate? Okay, well then this is fine. She can conversate. Now, that's what would have happened in an Indiana courtroom. I'm just translating in case.
Okay,
She has a pounding headache, and it doesn't help.
A pounding headache. Don't cry for her, Argentina. The truth is she has a migraine. I would, you know what? I am so petty. If I were the state prosecution, I would slowly pull up my purse at that moment, pull out my Excedrin and take two. Not even if I didn't need it. I would just be that. I am that level of petty. I am the level of petty that I would take out my Excedrin and take two in front of Shanda, offer her not one damn thing.
It's a stressful situation. I'm sure that's part of the what happens in these types of situations. But yeah,
as an officer of the court, do you believe she's not competent to go forward?
under
under the Michigan, under law in the state of Michigan, do you believe she's competent to go forward?
Yeah, I don't think she's incompetent, put it that way. She's able to communicate with me, yes.
We're going forward. She can communicate. We can teach her, how to sign things out. She's got a pen. We're rolling forward with this. Miss Vander Ark wants a new trial. Why would she want to delay?
But maybe, not at the best.
All right.
Especially with somebody that has a pounding headache. I can just imagine.
Can you imagine if any of the people on Omaha Beach had a headache? Doggone. I mean, imagine. What if Paul Revere had had a little bit of a migraine?
Did she take any medication for
I don't
headache or aspirin or
I don't think they gave
ibuprofen or,
any medication today.
okay. Is that something she normally would take for a
Yes,
headache?
she's,
Okay.
oh yeah, she does, she has a thyroid issue. She pointed out to me,
Okay.
that it's protruding. She's undergoing
I don't give a rat's ass. Again, her eye is trying to leave her face, her thyroid's trying to leave her body. Everyone is trying to get off of the sinking ship that is the Shanda Vander Ark, you know?
testing. Won't know the results for another couple of weeks if it's cancerous or not. There is a family history of that as well.
Okay. Ms. Pulquist.
Thank you, Your Honor. Well, I was going to argue that she's presumed competent until she shows otherwise, but given that's not the claim, then the argument would be whether or not there's good cause for an adjournment, and it's the people's position that a headache is not good cause. Additionally, the people are ready to proceed and put one with the Ginther hearing, but two, we do have some evidence that we could set forth to make the record as it relates to her appearance and how she was on the transport on the way here. We did have at the after the in-chambers discussion, jail medical came and looked at her, and it seems that she's been cleared by them, apart from having somewhat raised blood pressure. So I do think that we could make a record as to why this is not good cause. Additionally, Ms. Vander Ark, through her counsel, did give a waiver of HIPAA so that we could request some records from MDOC. They said that those would be emailed to me in approximately 30 minutes. They were going to do that expeditiously. However, the people would put forth as an officer of the court that in communications with the Michigan Department of Corrections, they would not have transported her had there been a medical issue raised before.
Yeah, that's the problem. If she were truly contagious, had any sort of fever or anything that could cause, an infectious outbreak in a, highly populated area, which a communal area, which prison is considered, they would not have transported her. I love that the prosecutor is like, actually, no, I have a headache too. It's called Shanda Vander Ark. So we're doing this.
Or transport. So, Your Honor, I think this is just, again, another dilatory tactic by Ms. Vander Ark to delay this hearing and to delay the proceedings. And I would say that there's not good cause. And additionally, I think the court can take into consideration all of the prior actions of the defendant, her prior reports, all of that when fashioning whether or not an adjournment is warranted. And it's not in this case, and we should proceed.
Oh, heifer's about to learn. This is why you should not cry wolf. Also, maybe when you systematically take the life of your special needs son, who did nothing more than wanted to be loved by you, yeah, people tend to not give a rat's rah-rah if you have a headache.
Okay. Did anyone, we obviously have the Department of Corrections officers in the courtroom. Did anyone talk to them regarding her condition?
I did, Your Honor. I did inform them they maybe needed to take some brief testimony.
Well, short of that, I mean, are either one of you comfortable doing that?
If you would like us to, we can.
Okay, well, why don't we have one? What's your name, ma'am?
Officer Scott.
Officer Scott. Why don't you have you come on up and I'll swear you in. What's your first name, ma'am?
First name's Autumn.
Autumn. All right, Ms. Scott, can you raise your right hand? Stand up and you swear or affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, put your hand down and grab a seat. Can you please state your name for the record, spelling your first name and last name?
First name is Autumn, Autumn. Last name is Scott, Scott.
All right, any objection with me asking some questions?
Please tell us that she was doing just fine until I can't. The vapors.
I'll let you guys follow up. Mrs. Lindquist, Mr. Ambrose?
No.
All right, good morning, ma'am. I'm sorry you're in this position. This doesn't usually happen. So, my understanding is you transported Ms. Vander Ark here this morning. Is that correct?
Correct.
And where did you transport her from?
Women's Huron Valley in Ypsilanti, Michigan.
Okay, approximately how long is that?
About 2 hours and 45 minutes.
Okay. And now I kind of understand the configuration. Are you in the back with her in the van, or are you driving with the front? How does that usually work? Where's everybody in the van?
It's okay. I was driving. My partner was on the passenger seat, and Ms. Vander Ark was in the back.
Okay. So you were more focused on the road?
Correct.
Okay. All right. So we probably need your partner. Now, were you able to observe Ms. Vander Ark?
I can see her through the rear view mirror as I drive.
Okay. Was she communicating with you at all?
She only spoke to us a couple times just to ask to turn the heat up or down.
Okay. Did she indicate that she had a headache at all?
She did not when we arrived. She did say that she was feeling a little nauseous,
Okay. All right.
a little dry heaving.
Okay, anything from, was it, no, okay, all right. Probably, did you ask where it was from? Was it from the ride or something like that, or you know?
She did say she does get car sick.
Okay, all right. To your knowledge, would the Department of Corrections transport a prisoner if they had a concern over her medical health?
No, and if she would have expressed it to my partner, then my partner would have requested to have healthcare come and clear her before we leave.
Okay. All right. Anything? Okay. All right. Technically, Mr. Ambrose, this is your hearing, so unless you want to go ahead, Mr. Ambrose.
I don't really have anything.
Okay.
Yeah, maybe because your client is what we like to call, why you always lying? Girl, you're always lying. I mean, you couldn't get away with it in your first trial, yet you're going to try the same thing again, and yet you claim you're super intelligent. There's something wrong with that math.
Ms. Robust?
Just briefly, Officer Scott, was she conversational?
She didn't talk much. And like I said, just to ask us to turn the heat up or down for her. Other than that, she was quiet.
Okay, you can stand down. Thanks so much. Do we want to put the other Department of Corrections officer on? Anybody input on that?
I'll leave that in the court's discretion, Your Honor.
Mr. Ambrose?
I don't have an opinion on it.
All right. Any other argument before I make a ruling on this, Mr. Ambrose?
Well, just that she did mention that she was nauseous, and that's consistent with, her headache, what she reported to me.
Okay. Ms. Punquist, anything else?
Yes, Your Honor, I just would ask the court to take judicial notice that Ms. Vander Ark, during this motion to adjourn, has actually been assisting Mr. Ambrose in the proceeding with writing notes to him about if she's taken any medication or if she has done anything to assist in in remedying her headache. So I think that I just wanted that to be on the record because I don't think the transcript would necessarily catch that. But as an observer in the courtroom, she has been actively participating in this motion through her counsel despite her claimed ailment. So again, I don't think there's good cause for an adjournment, and I'd like to move forward.
All right.
Yeah, Your Honor, can I just say, just my client writing a couple of notes down, is that supposed to be some sort of active participation? I don't think so.
Well, Mr. Ambrose, we're kind of in a catch-22 because I can't ask you what she's been telling you, and I can't judge how much she's assisting you without getting into what she's talking about. So I'm observing her writing notes and talking to you, which I've had jury trials where the defendant doesn't say anything to their counsel, and so why don't we do this? I'm going to do. The court also has experience with Ms. Vander Ark. Several times during the proceeding, during the jury trial, there were breaks in time where Ms. Vander Ark said she was undergoing distress. I granted those breaks. It seemed to me, and from the outside looking in, that these medical issues seem to be at times of pretty significant testimony in the trial. Not saying that maybe they weren't genuine, but they certainly.
Oh no, I am. This woman is not a good actress. Again, Sandra or Shanda, whatever your name is, I'm not even going to say your real name. Annie Hoozle, if you're going to pretend to be, getting sick, usually when you make that heaving noise, there's also a liquid splat. Now, you would think that as a mom, you would know this when your kids pretended to be sick, but you are just terrible. So yeah, I'll say they weren't genuine. The judge is being nice. I won't. They were terrible facsimiles of illnesses by a even worse liar and actress.
Certainly appeared to be situational. Also, when she was at a preliminary examination down in district court, there was a point of what she's claimed to be distress that appeared to be situational. We're here now, and I think it seems to be situational again. Again, she may be going through something, but I understand that adjourning this wouldn't necessarily prejudice the defense. However, there's witnesses here; they're ready to go. People took time out of their schedules. The court set aside an entire day for this. And there is something to be said for the swift administration of justice here. And so, based on what I have, I don't think there's good cause for an adjournment based on a headache, because that's all really the record's been made. And the only person that can judge if she really has a headache or not, quite frankly, is Ms. Vander Ark. And I don't know if she's telling the truth or not. I have no clue. I will say, as the finder of facts.
Because she's what we like to call a professional liar.
At the trial, didn't find her credible, and I don't know how much credibility the court can lay on her statement. So I'm willing to do this. I can take a break, wait for the records to come in, that way the court can review those. I also can offer Ms. Vander Ark, is our jail staff allowed to give her medication, like ibuprofen or Tylenol or something like that? Is that allowed?
I would assume if they discuss it with healthcare at the prison, that would be fine.
Okay, all right. So I don't, we have something downstairs. She can, I mean, I don't know what she takes, Mr. Ambrose. She'll let me know. I'm sure they have it all on. We can do anything we can to help with that. I'm willing to give her, you know, if she needs.
Sodium pentothal, bleach, antifreeze. I'm willing to give her many things to try to fix her. Any of the ramen noodles that I tried.
For blood pressure, I don't know, maybe she needs food or something. I don't know what it is. So anything that can accommodate to help her headache, I get it. If she's got a pounding headache, then I want to at least try to get her some help for that. So why don't we adjourn? We'll wait for the records to come in. Mr. Ambrose, let my staff know if she needs medication, and we can get that from the jail, and then go from there. Anything else before we break, Ms. Bloomquist? Mr. Ambrose?
No, thank you.
Okay, we're in recess.
All right. I guess they found her an ibuprofen.
People versus Shanda Vander Ark. All right. Mr. Ambrose, did your client, was she able to get some medication or no?
No, not yet.
All right. I know there's some bureaucracy stuff that goes on with
Yeah.
you.
The MDOC is the one that would dispense it, since my understanding, because she's not in Muskegon County custody, that it had to go through MDOC. So I did send an email to the person in charge of the MDOC, who would be the person that could.
It's almost like if you wanted ready access to headache remedies, you just don't commit felonies like murder, and you can be outside in the public with the rest of us getting Tylenol.
Authorize at least some medication.
How is her headache now?
Not good. I mean,
All right. I did get a copy of the medical records. I'm assuming that we don't want to make those a part of the record, at least certainly not an open part of the record. I guess, how do you guys want to proceed with that? I can make them a confidential part of the record.
Any sort of protective order, though, the defense will want.
Mr. Ambrose
that's
is
fine.
okay. So I'll make them part of the record. We'll call it the court's exhibit number 1. It'll be a confidential record. The court did have a chance to review those records. It looks like on the 22nd, without going into all the details, looks like on the 22nd, Ms. Vander Ark complained of that she felt like she was going to pass out. I don't think there's any indication in these records that she did in fact pass out. There was some concern with some thyroid issues when she was eating apples, I guess, and they basically told her, don't eat apples. That's what's in the records. So there's nothing in these records about her actually losing consciousness. She reported that she was going to pass out. There's also indication that she asked for some Dramamine for the trip to Muskegon because she typically gets car sickness. So that's kind of in line with the testimony that she felt sick on the way here, but she at least indicated that she gets car sick. So unless I'm missing something, it sounds like they sent her because there was no concern. So based on the records and what we've already done here, I think she's competent, and we're going to move forward today. I am concerned that she reported losing consciousness when a medical person indicates that she complained of feeling like she was losing consciousness, and that she's now kind of amplified for whatever reason, I don't know. But I am concerned about that, the fact that she misrepresented that to her attorney, potentially, that she actually lost consciousness, because there's no record of that in the prison. So,
Yeah, Attorney Ambrose, you might want to pay attention. Again, your client has a history of not telling the truth. And you, as an officer of the court, should probably, if you don't want to end up on the path like Mr. Gingras, you might want to validate everything that Miss Vander Ark says, like everyone should do with Laura Owens.
anyway, anything else before we move on, Mr. Ambrose?
Well, the only way that, she would have to report to the medical personnel that she actually did lose consciousness. So
Well, I mean, she okay, I get it, but the quote is, quote, I felt like I was going to pass out. I have tremors that are severe. That's what she reported on the visit November 22nd, 2025 at 6:45. And she was treated. She says the administrative note was that she was advised on site that the above patient came to the clinic concerned of dizziness and a tingling throat. The tingling throat was transient and only when she ate apples. And it says, the RN advised patient had a reddened throat, no swelling or lymph node enlargement noted. And eventually the treatment is, it says she did palpate in a large thyroid. However, the patient is, why don't we get into that? Says RN still had concerns about patient's fall risk. The RN exam otherwise unremarkable. RN gave the patient detail prior to calling. I advised RN to tell the patient to stop eating apples. Other than that, I did not have orders for this patient. So that's what happened on the 22nd, at least according to the note. Like I said, I don't know what happened, but these are medical records by individuals that I don't know if they'd have a reason to lie, quite frankly, if they're making a medical record. So, so based on that, I don't see a serious medical issue that is to the concern of the court. So anything else, Mr. Ambrose, on that? I mean, she can testify if she wants about what she's going through. That's fine, but.
Again, your testimony is where everything went wrong in your trial. You should have taken a plea deal, but let's go with your testimony. You're going to help yourself out.
If the request is for an adjournment because of a medical issue, I don't see it. So. I'm not, listen,
No.
I'm not going to delay this anymore. This is, in my opinion, Mr. Ambrose, she's misrepresented and through you to the court that she passed out. She did not pass out. So I'm moving on. I think this is gamesmanship on her part, and it's now 11 o'clock and a hearing that we were supposed to start.
Call her out to her face, to your face, Shanda, and no one has to listen to you now because you are what we call convicted and no one gives a crap.
At 9 o'clock. The court's been very patient with this, and we need to go. So,
Okay.
Anything else? Ms. Bloomquist. All right. So, Mr. Ambrose, this is your hearing.
Yeah.
You can call any opening statements on either side, or do you want to just go straight into witnesses?
We can go straight into witness.
All right. You can call your first witness.
Oh, Shanda did no one care about you. Wow.
All right, Mr. Johnson, if you want to come on up front here, sir. Good morning.
Good morning.
Would you raise your right hand to be sworn?
Yes, sir.
This matter now pending. Do you swear or?
Now, this was actually Shanda's lawyer at her trial. While he wasn't a remarkable defense attorney, he did the best he could with the facts that he had. Now, I do believe that Shanda was very, very pivotal in the kind of strategy the defense used, that she was an overwhelmed, single mom who, for all intents and purposes, had lost her husband at the time for medical reasons. He had moved out of the house and she was dealing with, 3 boys on her own and dealing with post-trauma. I do believe that Shanda was very, very instrumental in coming up with this kind of defense narrative. And this lawyer did a good job with what he had. Obviously, the state had a very good case. Shanda left all the evidence.
From the testimony you're about to give me the truth, the whole truth, and nothing but the truth, self you got. I do. All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
My name is Fred Johnson, FredJohnson.
All right. Mr. Ambrose, you're welcome to stay at the table or the podium, whichever you prefer. So you can stay standing, stay seating, it's up to you, okay?
Thank you. Mr. Johnson, you represented Shanda Vander Ark, is that correct?
That is correct.
Okay, and do you recall, you're an attorney?
Yes, sir.
Do you recall how much you drank to deal with this heifer? I'm asking because I'm going through 4 bottles of vodka a day and my liver can't handle it.
Can you tell us when you became an attorney?
1984.
And I apologize, Your Honor, before we start. Ms. Vander Ark, Mr. Johnson may be getting into some confidential information. You understand that?
Yes, sir.
And you understand that by going forward with this type of hearing, that he's going to relay some confidences.
Yes.
Are you okay with that?
Yes, sir.
Do you have any questions regarding that?
No, sir.
Okay. With that disclosure, Your Honor, I'm going to proceed with.
Okay. Anything else we should put on the record regarding that you want, Ms. Bloomquist? Okay, all right, good enough.
What year did you become an attorney?
1984,
Okay, and where'd you go to law school?
Thomas M. Cooley.
And so from 1984, have you always practiced criminal law?
I have always practiced criminal law, yes.
Okay, and has your license, have you continuously been an attorney ever since 1984?
No, sir, my license was suspended last year for 6 months.
And what was that? So it was suspended last year for 6, what was the reason why it was suspended?
Violation of confidentiality, conflict of interest rules.
Okay, and that was while you were,
Okay, so maybe he's not the bestest attorney, but still he had to deal with Shanda. Also, he reminds me of Master of Disguise. Am I not turtly enough for the Turtle Club? Okay, sir, better posture, and I won't think about the Turtle Club. Shoulders back, you know, just think about it, because you're gonna get a hump.
a public defender,
Yes,
and when you represented Miss Vander Ark, you were a public defender. Is that true as well?
yes.
And the initial allegation that was lodged against you, when does that go back to?
Oh, gosh, that was, I couldn't tell the year, 5 years ago, perhaps 6.
And when was the complaint issued against you?
2024 is my guess.
Okay, and
2023 perhaps.
Shouldn't you know when you get a complaint? I mean, and I'm guessing a lawyer would get one. I'm guessing in the normal course of a career, you might get 1 or 2 complaints. You're a lawyer. You're representing, people for criminal defense. I'm sure 1 or 2 convicted people might think that you've done a terrible job. But shouldn't you know when you break confidentiality or conflict of interest? Shouldn't you could remember that?
did you admit to the grievance?
Yes, I did.
And what did you admit to?
I admitted that I had received information from one client while representing another client, and the person who the information I received was the victim in that case, in the second client's case.
And again, this was while you were the public defender?
Yes, sir.
When did you take on that role?
2013,
And
September.
what did your office consist of?
In 2013,
Throughout the years?
it grew over the years.
Okay.
We started, I think, we were at 13, and by the time I left, we were in our 20s, maybe 25, 26.
Okay.
And that includes staff as well.
So you mentioned that you admitted to the allegations within the grievance,
Yes, sir.
and what did you have to do as a result of your suspension?
I was suspended for 6 months, so I could not practice law. There's a fine and costs.
Were you required to take any type of classes?
Was I required to? No, I didn't. I was not required to. I did, but I was not required to.
What type of classes did you take?
On ethics, conflict of interest.
Okay.
Yeah, you probably should brush up on that before you have to pay another fine.
And did you testify at any of these hearings?
Which hearings? The ethical issues hearings? I don't know if it was testimony or not. I made a sworn statement at the time of my initial interview, and I spoke to the state bar. I think that was on oath as well, so that both might be considered testimony.
Okay. And part of your disclosures were that you're more or less overworked. Is that accurate?
Was I overworked? I think I was.
So Shanda is the product of a poor, overworked defense attorney, and not the fact that the state had all the evidence and Shanda wanted to have the jury buy this ridiculous idea that she blacked out and, this, you know, alternate personality took over during these blackout states that wanted to torture her child, or that she's just a horrible person who did it herself because it feeds something in her monstrous soul.
And would you disagree with, I was working too long, I was working too many cases, too much stuff, too many irons in the fire? Is that something that you may have said?
Yes, sir.
Any disagreement about that?
No, sir.
Also, basically, when I was a public defender, I was working on a conveyor belt system, and the problem that came up on the belt next is the one I tackled and tried to keep the other ones juggling until I could fix them as well. Does that sound like something you might have said?
Yes, sir.
Now, this case with regard to Ms. Vander Ark, do you recall when you initially, how is the assignment system conducted in Muskegon County?
You mean back then or now?
When you were assigned?
When I was public defender?
Yes.
Okay.
Wait a minute. Are you still currently a public defender after apparently, you know, having complaints and being overworked? I have questions, Muskegon County.
The attorneys are assigned to judges, and whatever case the judge received, that attorney assigned to that judge will receive that particular assignment. Normally, that was the situation, unless something came up and we'd have to change assignment for whatever purpose might have occurred.
Is there a private bar that receives assignments as well, or is it just everything that every indigent client goes through the public defender's office?
Things have changed over the years. Things have changed over the years. Currently, all the indigent individuals go through the public defender's office. There is a private bar, however. Are there assignments to the private bar? On occasion, there are, and there were.
Upon receiving the assignment, do you recall when you would have first talked to Ms. Vander Ark?
I would assume it was before the preliminary examination, but I don't have a specific recollection of any particular dates.
At any point in time at the preliminary examination, with your initial conversation with Ms. Vander Ark, did she ever admit to any type of guilt?
No, sir.
All right. Now, she contended that she was innocent throughout this case, isn't that right?
Yes, sir.
Laughably, I mean, beyond all suspension of doubt, beyond credible, well, mental faculty, yes, she said she was innocent.
Testified, right?
Yes, she did.
She never admitted to any type of wrongdoing that caused the death of her son.
That is correct.
Now, while you were assigned to the case, did you have Ms. Vander Ark see a professional with regard to competency or criminal responsibility?
I had Ms. Vander Ark see several professionals, 2 doctors, and we employ social workers on our staff.
With regard to, do you recall having Ms. Vander Ark seen by Colin King, Dr. Colin King?
I do recall that.
And in Mr. King's report, did he do a report?
He did.
And do you recall what the results of that report were?
I don't recall the specific results. I recall the conversation we had in regards to that report.
As part of his conclusions, would you agree or disagree that he mentioned that Ms. Vander Ark continues to insist she did nothing wrong and was not convinced that her actions and instructions caused the death of her son?
I don't recall.
Her delusions are not our problem. The fact that Sandra doesn't think she did anything, or Shanda, Sandra, look, Shanda, I don't care what this heifer thinks or what. 12 of her peers decided she was all the guilty for this. Yeah, I know, JKD Buck, but can we add more years for pissing me off?
Specifically, if you have a report, it might refresh my recollection, but I don't argue with that statement. It sounds, generally speaking, as what I recall.
May I proceed?
Yes, sir.
And it's an accurate statement that she had stated that to this doctor that she felt that she did nothing wrong. Is that correct?
Yes, sir.
And you went to trial on that basis, right?
We went to trial because she was charged, sir.
And she proclaimed her innocence, right?
Even had she not proclaimed her innocence, when we've gone to trial and she's charged with first.
Yes, it's an adversarial system. She would have gone to trial. You know, she can be tried in absentia. She doesn't even have to physically be in the courtroom if certain procedures are done. So again, she was charged, so she was going to be going to trial to have her, rights to confront her accuser and all those other things, put into place.
Murder. But yet she proclaimed her innocence from beginning to end, and we tried the matter.
Were there any offers made to Ms. Vander Ark?
None that I can recall, Your Honor. Sir.
Now, Ms. Vander Ark testified at trial, right?
Correct.
And she again proclaimed her innocence to the charges, right?
That's correct.
And there was an incident on the day of her testimony where she had a physical reaction to seeing a photograph of her son.
Yeah.
I believe that was, if we're talking about the situation where she turned and there was a trash can there and she appeared to I don't know if she actually did vomit, but she had the body language was indicating that's what was going on. I was sitting in the chair where the prosecutor is.
And during her cross-examination was, you described the cross-examination for us.
Aggressive and effective.
Okay, aggressive and effective. And did you see Ms. Vander Ark after court that day?
I don't believe I went out to the jail to see her after court that day, no.
Okay, did you go into lockup with her after court?
I can't honestly tell you that.
All right. The next day, can you tell us what happens?
And if my recollection is correct, the next day, court was resumed and my client, Ms. Vander Ark, was unable to attend. She was unable to come to the hearing, as I recall.
And you reported that to the court, right?
Yes, sir.
And you stated to the court that she had some competency issues at that point. Is that correct?
Some competency?
That she wasn't able to proceed.
Yes, and yes, sir.
Again, competency means something very, very different. It means she's able to, again, effectively communicate via various different means, whether it be writing on a piece of paper, but she's able to comprehend where she is, what's going on in the trial. So she's trying to state that she in some way told her attorney during her trial that she was having competency or sanity sort of her issues, and her lawyer didn't effectively communicate this to the court. Now, I think the judge clocked her, and I think everyone clocked her as faking sick to get out of her trial that was going terribly for her.
May I approach you, Daniel? And this is, I'm showing you a transcript of December 15th, 2023. It's on page 3. If you can just read that portion.
Yes, sir.
And so you indicated to the court that she wasn't competent to proceed, is that right?
That is the word I use, sir.
Okay. And you describe to us what she was going through.
She was, when I went to visit her, she was curled up in a ball on the floor. She was crying. She was upset. She,
Yes, someone finally called you out on your craptastic dumpster water human behavior, and you not being able to deal with any sort of criticism because of your fragile psyche, decided to try to make it about you.
she expressed that she couldn't return to court. She expressed that she was upset, that she was stressed, that she was experiencing, and I'm sorry, I forget the word. She experienced a period of where she's so emotional she can't function intellectually.
And based upon that, you reported that to the court.
Yes, sir.
And you also, do you recall reporting to the court as well as that if we waited until, or adjourned the matter until Monday, Tuesday, or Wednesday of the following week, we'd be in the same situation?
I don't recall, but I'm not arguing with it. I assume you have transcripts there. I don't recall saying that, but.
If you look on page 4.
Which paragraph, sir?
The second full paragraph,
Okay,
starting with the word 1.
okay.
And you agree that you told the court, we couldn't guarantee to the court that as of Monday or Tuesday or even Wednesday of next week, we'd be in any different situation than we are right now.
That is what I said.
And was that an accurate assessment?
That was my assessment at the time, yes, sir.
Okay, so one of the things that you argued or suggested to the jury was that Ms. Vander Ark was guilty of manslaughter. Is that right?
That she was guilty of manslaughter.
Yes.
I don't know if I used that term. I don't recall arguing on the manslaughter issue. Can you tell me which page?
Yes.
Manslaughter. Oh,
I have this broken up, but it's on page 84.
Okay. Do I have it?
Yes, in the back.
Okay.
Agree, disagree.
Whereabouts on 84, Council?
It's actually on the very last page, page 80.
All right.
First full paragraph. And you told the jury, these people, and I'm assuming you meant Paul as well, these people committed manslaughter. That's what they did.
Yes, sir.
They caused the boy's death. That's
Yes,
what
sir.
you said.
Okay.
Now, Ms. Vander Ark never gave you consent to say that she was guilty of anything, did she?
No, sir.
And so you kind of took it upon yourself to make that argument to the jury.
Yes, sir.
But that's okay because there are certain things that Shanda did have the right to, decide whether she was going to testify, whether she was going to take a plea deal. Defense attorneys are the ones that are supposed to be in charge of the strategy of who to call, of what witness and what evidence can be shown or should be shown in the case. So he was well within his rights of most, counsel kind of client relationships to do what he did. He was giving the jury an out. Shanda was not going to walk out of there not guilty. The jury had seen too much. He was trying to give a lesser and included out, where if there was one juror who believed that maybe she, this was a mental health thing, that they could give her that. But no one on the jury believed that this was, or believed Shanda's theory that this was a mental health thing. So she's arguing more with the jury's interpretation of the evidence than what this lawyer said.
I have nothing further.
Morning, Mr. Johnson. How are you?
I'm well, thank you.
So I'm just going to go back a little bit more into your experience. How many years have you been a practicing attorney?
41 this year.
And how many years of that as the chief public defender for Muskegon County?
2013 to 2024, so 11 years.
Is it fair to say in your role as the chief public defender, you would take some of the more severe cases that the county has seen?
Yes, sir.
Okay.
Yes, ma'am. My apologies. I'm on the roll here.
Now, just sort of getting into some of the comments that were brought out from.
Also, can we just take a moment that this prosecutor came in and she's like, I will be looking professional, polished, everything that Shanda never was always a cheap, pale imitation. I love that this is petty on a female level because she knows that she is everything that Shanda wanted to be, and she's up here with fabulous hair. Jen, basically, Shanda is trying to argue that her defense attorney was basically for ineffective counsel. She feels that he commented on her guilt out of turn, basically claiming in closing statements that she could be charged with manslaughter, not murder. Now, the jury disagreed with that, but basically, she's trying to say that the lawyer didn't effectively communicate how incredibly mentally out of it she was after she testified. If you remember on her trial, she did her, direct and then her cross with the state. The day ended, and then she didn't come back. Claimed she was too sick. So now we're getting, yes. So her counsel is on the stand, and basically we've gone through what Shanda is really upset about, and now the state is going to be questioning this gentleman.
Your sworn statement or things like that. There's discussions about your workload. You recall that? And maybe feeling like you had a conveyor belt system.
Yes, ma'am.
Did a case like this fall into the same category of cases you were discussing in that?
No, the cases like this get the spotlight. They come out of the group, of the pack, and we place not only my efforts, but the social workers and other attorneys on staff. We all work on cases of this magnitude.
Okay. So although there's testimony by you to the effect of being overworked and that impacting some of your cases, is that an accurate sort of representation of what's said?
It certainly impacted the one where I saw that information. I shouldn't have seen it. It impacted there. That's what I think is happening. So, but I'm sorry. Go ahead.
No, and that's okay. And just to be very clear, the case for which you had your suspension had absolutely nothing to do with this case, correct?
That's correct.
No witnesses between Paul and Ms. Vander Ark. That wasn't the conflict at issue.
That's correct.
Okay, it was a wholly unrelated matter.
Yes, ma'am.
And while we're on that topic, did you have to sit in that exact same witness chair and again through hearing on that case as well?
Yes, ma'am.
Okay. And you testified about the allegations and the conflict that was alleged?
Yes, ma'am.
So getting back into your prep on this case specifically, let's walk the court through your preparation for trial. Let's start with prelim.
Okay.
Walk us through your preparation for preliminary examination on this case.
Well, I assume all lawyers do. You receive information called discovery, and you pour over it. You go out and see your client. You talk to your client about what's going on and what her impressions are. You come back and you go over it again. You bring in other attorneys to take a look at issues. You run issues back by them, see if they have any similar experiences or any pointers that they may want to bring to bear. You bring another attorney in, usually a younger attorney, in to sit and to watch the whole process. We also employ interns here, so. The beauty of interns is, whereas I may have multiple cases, they only have the one, and they pull over the documents and the materials, and if there's anything in there that they see, then they can bring it to my attention. But it's a fallback situation, so we can bring other eyes on it. And there was no different than here, Ms. Van Aert. We did all these things. We worked dozens of hours just for the preliminary examinations, and we were ready to go.
So it sounds like you created a team, so to speak, for Ms. Vander Ark.
Yes, ma'am.
How many people would you say were on that team?
Over time, coming and going, over time, from the time we got the case to the time we ended, maybe 4 lawyers, an investigator, 2 or 3 social workers, so we're up to 9, and a half a dozen interns, so about 15.
Yeah. So again, this was a highly, prepped case. And as much as I made fun of this attorney, for what were obviously more Shanda's kind of narratives, he did what he could do with the evidence that he had. He made sure that the state had to pull, the chain of custody and that all of the video information, all of the text information was gotten correctly, that the chain of command was used, or not chain of command, chain of custody. So he did a valiant job with the facts that he had. Shanda just gave him a really, well, crappy set of facts. She was all the guilty. Like, it's just
16, something wrong that line.
So 15 or 16 people working on her case specifically?
Over the course of time, yes.
Okay. And as part of your preparation for trial, now let's shift to preparation for trial. You talked about hours for preliminary examination. Could you describe to the court your preparation for trial?
Well, at this point, we've had time, a year, to look at this thing. We've brought in experts to examine my client. We've gone out to the scene of the crime and taken photographs and walked around, got the feel of the place. We've talked to multiple folks who we were considering, but we ultimately didn't hire. We spoke to outside social workers to see if any of them had come across any episodes along the similar line. We even saw an article in People magazine about a woman who thrown her kids out the window and then jumped herself. And quite frankly, it was eerily similar. And quite frankly, I'm still convinced there's something to do with my client's conduct. But it was hundreds of.
so your client is like other narcissistic monster mothers who don't give a crap about their children's safety because of whatever they're dealing with? Yes, yes, most moms or fathers or parents who take the lives of their children are dealing with some sort of mental health issue. Now, whether that goes up to the didn't know right or wrong, and then there are legally held not competent or not liable for that, is different. Shanda was perfectly competent. She was able to keep a legal clerkship job. No, no, none of this. Shanda got extraordinary help. She just had a crappy case.
Hours and I'll put in a couple hundred hours myself on it, and then you add in what everybody else is doing. It's a lot of time. It's a lot of effort. And I've told her I think if she had to hire, she'd spend $1 million on what we did for her in terms of trying to prepare and defend her in this case.
So just so I'm clear, you yourself dedicated hundreds of hours personally to this case?
Yes, ma'am. It was either I'm reading something or I'm talking to somebody. I'm looking for this needle in the haystack. I believe then, and I believe now, there's something wrong with my client. And
Yes, she doesn't have a soul, but we can't legislate morality. So we would just like to keep her kindly away from the rest of us, okay? Yes, there's something wrong with her, but we don't have the time or the money or quite frankly, the microscopes to figure out where her soul is. So we just keep them in jail.
And there's somebody out there who would be able to tell me what it was. And I still believe that to this day.
So I want to dive a little bit deeper. You said that you sought out experts, correct?
Yes, ma'am.
And were some of your experts from the Center for Forensic Psychiatry? The sort of state-run?
We use the appellate defender has a website, and they have a listing of witnesses, expert witnesses that other lawyers have used, and we use their list in determining which ones to approach. We also use here from the other lawyers in the office. Have you used anyone in these circumstances? Do you know of anyone? And those are the lists we use.
Okay. And so I know the record will reflect this, but I want to ask you, do you recall having a criminal responsibility report done for Ms. Vander Ark?
Yes, Dr. Watson.
And do you recall also having a criminal competency report done as well?
Yes, ma'am.
And now those were ones that I believe were filed with the court, correct?
Yes, ma'am.
Were there reports that you, or examinations that were done and reports that were drafted that were not filed with the court on Ms. Vander Ark's behalf?
I don't know if we filed Dr. King's report or not. I don't think we did.
Okay. And did you also get a report from a George Watson Jr.?
Yes.
Okay. And to your knowledge, was that ever provided to any, to the court or to the parties?
To my recollection, no.
Okay. Is it fair to say that you did a lot of investigation into experts who could testify about her mental state?
I think that is fair.
Why didn't you present those experts?
The conclusions the experts provided would have been supportive of a verdict of guilty of murder.
Basically, none of the experts every expert took 2 looks at Shanda and were like, yeah, you know what? She's a little nutty, but she's just a bitch. And she's guilty. 10 out of 10 experts agree Shanda's guilty as sin.
Their positions were uniformly and enthusiastically negative towards my clients. They would have been
Not uniformly negative. I mean, at least with Trident, 9 out of 10 dentists approve of Trident. I mean, damn. That's more than Trident gum. You got 10 out of 10 dentists just do not like Shanda.
They would have been prosecution witnesses that we presented their findings.
So you intentionally did not call these
That
experts?
is correct. We intentionally did not call them.
And that choice was made after a thorough investigation of their opinions, correct? Or I guess explain the investigation that went into that.
He's like, ma'am, we took one look at him and it said she is a butt monkey from hell who I wouldn't pee on if she was burning by the side of the road. And we were just like, we just hope Shanda shuts the hell up. That was the only thing we could figure.
Dr. King, for instance, when I spoke to him, his response was, she's a monster. His response was, she's the worst thing he did.
Fucking yeah, let's have Dr. King talk. I want to hear Dr. King's fireside chats roasting the hell out of the monster Shanda. We're backinating.
His response was, she's a monster. His response was, she's the worst thing he'd ever seen. And he's a man who testified for mass murders. I did.
Oof. When someone would rather testify for Ted Bundy than your ass, Shanda, I mean, that's an achievement. When someone would rather defend Nicholas Cruz than your ass. That's an achievement, ma'am. I mean, you wanted to achieve something extraordinary. Congratulations.
Did not want to bring his testimony in. Dr. King simply said that she was competent at the time, and she was competent for trial, and he had and that's not what I wanted the jury to hear. I want the jury to hear that there's something wrong with her.
So let's get into, and I hate to zoom out here from these details, but what was your overall strategy?
The overall strategy was to attack the issue of premeditation, that my client premeditated when she caused the death of this young man. Our strategy was to demonstrate that through, especially her text messages, that she was, for whatever reason, unaware that her son was suffering and was close to death. And
You had 15 people and all of you thought this was your best idea? I can see why you're no longer the public defender, but this was your aim material? That Shanda was too stupid to figure out what was going on while she was holding a highly critical legal career down and functional in society to the point where she wasn't Baker acted. No one else noticed she was crazy, but she was able to fugue state her way through all this abuse. Seriously? 15 people, and this is what y'all came up with?
tried, especially with her text messaging at the time, to demonstrate that that was the case.
And I know you previously said you were looking for a needle in a haystack for something in your defense, correct?
We were looking for the cause. If you understand the facts involved in this case, this young man was her son. This young man, she could have refused him. She could have refused even to take him into her home. She brought him into her home to care for him.
She brought him into her home to have something to abuse. This woman thrived on torturing people. She didn't give a crap if her house was clean, but she sure as hell could make sure Timothy was on camera. So again, I don't know how you sold yourself this idea, but you should have known this wasn't going to fly.
This young man was killed in the most brutal, heinous way that you can imagine, slowly starving him to death. the two, and it probably is just because that's the way I'm built. I just can't believe that a healthy person would have done the things that she did. I don't.
No, she's evil. Evil doesn't need a reason. In fact, the reason that Shanda gets so many chances is because people like you are searching for a reason, her childhood, a trauma. No, sometimes evil is just evil and it doesn't have a rhyme or a reason. And we just need to keep these people safe from humanity by keeping them away from society. We don't need to have a reason. We don't need to know why Brian Koberger did it. We don't need to know why Paul Canero did it. It's just evil. It doesn't have to make sense, and it never rarely does. And whenever they come up with some jackass reason why they did something, it usually isn't anything that makes sense to anyone anyway. So, yeah, the reason she did what she did is because she's evil. It's not because she has a screw loose.
Believe it to this day.
Now, the realities of this case and the nature of it is something you have to factor in your preparation, correct?
Yes, ma'am.
And you did, in fact, do that?
Yes, ma'am. The evidence? Yes.
And now you've talked about these hundreds of hours. Have you also, in preparation for this trial, did you engage in witness preparation?
Of my client?
Of anybody?
Yes, we talked to my client about her role and how we were going to decide once we got there if she's going to testify and the sorts of things she might be asked and the sorts of things that we'd be asking of her. Our only other witnesses would have been the experts had they been called. And so there wasn't anyone, or the social workers. And since we didn't call any of those folks, it wasn't necessary to prep any other witnesses for testimony.
And additionally, in preparation, did you evaluate filing motions to suppress or other sort of pretrial motions
Yes.
on this case?
Certainly. And that was the value of the group think. You have several lawyers and you're asking them, and an investigator, what about this issue? What about that issue? Should we file a motion on it? Should we attempt to take it to the Court of Appeals? Did we lose that sort of thing? All those issues were discussed.
Did you also prepare for your voir dire in this case?
Yes, I did.
Okay. Are you aware there's an allegation that you did not prepare for voir dire in this case?
Yes.
Okay. And in preparation for today's hearing, did you provide to me some documentation from your file regarding your voir dire?
I did.
Okay. Would you like the people to be numbers or letters given today's proceeding?
Let's do numbers. We'll stick with consistency, unless someone's pre-marked exhibits, but we'll do numbers.
Okay. I'm going to be showing, may I approach?
You may.
All right. I'm showing the witness what's been marked as People's Proposed Exhibit 1. Did you identify what this is for the record?
Yes, this is my standard voir dire sheet, in which 4 pages of.
Oh, Shanda, please, you're going to get on the stand, I'm sure. In fact, let's go through this. I'm sure you're skinny, ridiculous behind. Oh, they do let her talk for shortly, but no one gives a rat's. The man had paperwork. You just had a shitty case. End of story.
Questions that I may or may not be asking depending on the nature of the case, but certain things that I want to make sure I cover and ask the juror or potential juror before they're seated.
Okay. Do you recall if you used this preparatory document in your trial?
Yes, I did.
Okay. And I know this is a blank version, but did you take notes on it during the trial? Or?
Yes, I did.
Your Honor, at this point in time, I'd move for the admission of People's Exhibit 1.
Mr. Ambrose?
I'm sorry.
There's been, I'm moving for admission.
Oh, I have no objection to this.
All right, so Exhibit 1 is
You can
admitted
just leave that.
without objection.
What did you do to prepare for voir dire? Was it all contained in this document, or what else did you do?
No, ma'am. The day before, a couple of days before a jury trial, the list of potential jurors are made available to the parties. We got that list, and there's some information. It used to be better when it was handwritten, but now the computer stuff is not as helpful. But there is information, and we and I say myself and the interns go over this information to discuss potential jurors. We're looking for folks that we want to keep on the jury and folks we don't want on there, and so we're going over these things and we're asking questions back and forth. Do you know these people? Have you met these people? Are these people witness? Are they friendly to us? Will they be hostile to us? And we're going over that list. And so we've got notes. When we come into court, we have notes on the witness list that they gave us as to individuals we may not be called, we may not wish to ask on the.
Well, and I don't think that there would be any. So again, he did the best he could, but there really isn't, a sort of person that you could pick that you would think, okay, this person might be more sympathetic to mental health. Because, if you get someone who maybe has a healthcare background they're going to realize malnutrition. So really, I mean, as long as a person could state, I will judge the evidence fairly and I can presume that she's innocent until I hear, the evidence. The fact is they didn't really have a winnable case with all the evidence, with how awful Shanda is, how she presented herself. There was nothing this man could have done. Not even Johnny Cochran could have gotten Shanda off.
Sure. A police officer. If it's a police officer, we're probably going to ask him to be removed or her to be removed. So we go over that. When we get to when we prepare, we're looking at which of these questions are important to us and which ones are not. The way voir dire works, as you know, they're asked, did you hear all the questions and would you answer any different? So we can't ask the same questions over and over. So what I try to do during my voir dire is specifically save out some questions so that every time I take somebody out, I have new questions for them. The whole panel hears them, but they're new questions and they kind of help keep the interest of the rest of the panel. So that is part of the voir dire preparation. The reality with voir dire is if you pick a bad jury, the case is over. You're done. You've got to emphasize that part, because if the jury's not listening to you, it doesn't matter how brilliant you are afterwards. The voir dire has to be effective for your client, so we put a lot of emphasis on it.
And you specifically did in this case.
I specifically did in this case.
Now, is also part of your voir dire come from experience?
Yes, ma'am.
And could you give a rough estimate before this trial how many jury trials you have conducted?
Misdemeanor. Oh gosh. Misdemeanor and felony, maybe 2 or 3 a year. Felonies, and back when I worked before I became a public defender, 10 or 15 misdemeanor cases. Literally a couple hundred. I don't know. I've lost track a long time ago.
You don't keep a sheet with them?
Yeah, at least 10, 15 a year for 30 years. So.
Thank you. But you have vast experience in selecting a jury, correct?
I've done it many, many times.
And is part of selecting a jury knowing potential jurors out in the gallery that might be called up if you excuse somebody?
Yes, ma'am.
And I guess, do you see your obligation as a defense attorney to make sure you use every preempt, or to make sure you get the best jurors seated in those seats?
I want the best panel, and I tell my folks, the young folks, it's not how many questions you ask the right questions. You don't need to ask 100 questions. So there are occasions when my voir dire may be brief, but hopefully is effective. And I'm talking, and as Judge Casey will tell you, I talk loud. Like everyone in the courtroom can hear me when I'm doing my voir dire. I speak to the people on the back as well as in the panel. So yes, I'm aware of the panel here, but I'm also aware of who's sitting out there in the jury. Sometimes taking a person off the jury doesn't mean you're going to replace them with someone better. That's the Detroit Lions philosophy. Just because you replace somebody doesn't mean they're going to be better. Sometimes once you got the best you have, you stop talking.
Did you feel like you had a good panel in this case when you concluded voir dire?
Every lawyer says, I want a fair jury. We don't. We want a jury that's going to do what we want. I want a jury that's going to say not guilty. I got a jury as close to that as I was going to get from this panel.
I very much like his answers. Again, he's very honest. This woman, or Shanda was uniquely unlikable. She was already charged with a uniquely heinous and just gruesome crime. And I think that, again, he showed that he did the best that he could. Shanda wanted to be found innocent, and that was never going to happen.
So I'd like to shift a little bit and move into your interactions with the defendant. Do you recall, and it can be approximate, how many times you met with her personally?
Gracious, no. I couldn't meet with her. Well, okay, me personally. Gosh. No, it was, I tried to go at least every other month, so we had a year, maybe 6 times, maybe. And then during trial, gosh, and then after trial, and then are you counting the time after trial when I went to Jackson to meet with her?
Well, let's
Or just before trial?
let's say before trial,
Okay.
but then I'll get into the Jackson.
Half dozen, somewhere between 6 and 10, something like that.
And that was while she was lodged at the Muskegon County Jail?
That is correct.
Okay. How did those meetings go? What was the general atmosphere?
The meetings went very well, notwithstanding what she was convicted of. Ms. Van Hart was a wonderful client. She was a client from heaven.
Do what now? Again, I have seen the RFB on that woman. The fact that Look, I would simply open up the hole, put the papers through, and then run the hell away. Over here, she was a client from heaven. Well, thank God she wasn't in charge of feeding you, Al Roker. You'd look skinnier than you do now.
We talked. Her conversations were on point. She used time well. She did keep me after the point of the visit was over. She asked good questions. She responded well. We had and we have a wonderful attorney-client relationship.
And so it sounds like she was a cooperative.
Until she threw you under the bus, bro. I mean, you are testifying right now because she has thrown you under the bus and is attempting to back over you multiple times. First, alleging that you didn't, communicate that her competency or her sanity was, on the line, then saying you didn't prepare for voir dire. I mean, this woman is trying to attack your job. I would the petty would be strong. I'd be like, "Look, she had a ridiculous idea that people were gonna find her not guilty if we, came up with this stupid story that none of the experts would go with." I mean, sir, you're ready to retire. Just burn it all down.
Oh, absolutely, always, always.
And she had, would you say, above average understanding of the proceedings and what was coming with the trial?
She's a lawyer. She went to law school. She graduated from law school. She missed one question on her bar examination. She clerked for 2 judges. She must have sat in on a dozen felony murder cases, sat in and watched them. So she had as much experience with the law as somebody who has never practiced could possibly have. She was, and our interactions were tailored towards that. It's not one cookie cutter for every client. Her situation was different. She could understand and put together the facts and circumstances in a way that a layperson couldn't do, and that was very effective for her, and and I appreciated it.
And in those discussions with her, is it fair to say you discussed trial strategy with her?
Yes.
Okay, what was that trial strategy?
The trial strategy initially, and hopefully when we began, was to find that there was no intention, there was no premeditation, and that there was something mentally wrong with the person that committed this offense. Quite frankly, and I would tell my folks when I first met her, and in the first 6-7 months we worked on this, I would tell them there must be somebody else living in that head along with her, because the person I knew and the person who did these things, they just didn't matter. So our hope was to find somebody.
No, you were simply never vulnerable to Shanda. If you had ever been in a position to be in a vulnerable, setting with Shanda, you would see the person she really is. You were useful to her, so she showed her forward-facing mask. But if you were ever as powerless as Timothy, you would see the real Shanda. You can see the real Shanda now when she doesn't get what she wants. Um, uh, Ackerman, she took the life of her 15-year-old special needs son by systematically not feeding him, basically keeping him in a closet. I covered the trial. It was really hard. I will say that the trial was hard, but the state and the judge in the Shanda Vander Ark trial did a very good job of not flashing pictures up, of it not being a spectacle, of really respecting the victim in the case. Now, she is trying to get a new trial because she's claiming that the gentleman on the stand, who is currently being questioned by the state's attorney, and was her public defender in her trial, was ineffective. So she's basically claiming that she needs a better trial attorney because her first attorney was really bad. Now, she also happens to be an attorney herself, and she was actually very, very, kind of interested in the strategy that her defense would take. Now, there are certain things that, defense attorneys are required to get their input from their client about. That would be if their client wants to testify and if their client wants to take a plea deal. Now, strategy and whether to put on experts, whether to, have one expert talk or another, is up to the lawyer. So I think that Shanda is trying to have it both ways, basically saying that he followed her but didn't follow everything to the letter of what she said. So she is just being a butt monkey. And thank you so much, R.J. Wright, the novelist.
Who could put a finger, this is what she has, this is what's wrong with her. When that proved to be didn't bear fruit, we moved to, okay, when did she perform, when did she create the intention to even injure her son? Because our argument was she never formed it.
Did you discuss manslaughter with her?
Yes, manslaughter, murder in second degree, all the homicide crimes, we discussed each and every one of them.
And you read portions of your closing argument.
Ma'am, you are delulu. Your defense attorney was doing what was within his purview, which was if any juror was inclined to give you grace and find you guilty of something, but you didn't form the necessary mental malice, that you unintentionally starved your son and filmed it. Actually, he was called by the defense. This is actually cross-examination. Basically, it's both cross-examinations, but he has already been talked to. Yes, actually, her lawyer talked about the fact that they did actually reach out to 2 experts about any mental defect that may have caused this. And one expert only said that they were competent, and the other expert said she was an evil monster. So basically, both of their experts would have been state witnesses. So he didn't call them. And the defense attorney, yes, he's been with the public defender office since, I believe, 1990 or 2000 and something. Pretty much, yeah. It's kind of odd to see the defense, or the public defender's office, or former public defender work very closely with the state, to keep Shanda in prison.
Yes, ma'am.
And did you discuss with her about conceding manslaughter in your closing?
I don't remember that.
Okay. Why did you concede manslaughter?
The volume of evidence and the type of evidence was massive. And if you look at a jury and you tell them that nothing's wrong when it's clear to even somebody hasn't paid attention that something wrong has happened, you lose them. And when you lose credibility with the jury, they never listen to what you have to say after that. Quite frankly, I was hoping for murder too. I told them manslaughter because that would give them the space to move up. But I was hoping that they would see me as a fair dealer, as an honest person who looked them in the eye and told them this is what's going on, and I'm not going to try to lie to you or throw lawyer tricks and fool you if the gun, if the glove doesn't fit it, you must have quit that.
She got first degree red rum. And I think that the state did a very good job. There was plenty of digital evidence. There was text messages, photos, video evidence. There was so much that this woman knew. She actively enjoyed the things she was doing to her son. And you will never be able to prove to me that she didn't get a heck of a, whether it was a stress relief, a boost, hell, a little funny feeling in her lady bits. I don't know, but she got something out of it because it was her favorite, reality TV show. The judge clocked her on that in his sentencing. She was not unaware of what she was doing. She was actively figuring out ways to withhold things and make torture. She is, of all the people that don't need another trial, a person that benefits greatly from our due process system, when in the old Western days we'd have taken care of this another way. She shouldn't be pressing her luck right now.
That stuff, I'm an honest guy. This is what I honestly think, and this is why you should think it. So I had to concede something because, quite frankly, the evidence was overwhelming, and the prosecutor hadn't even put in his best evidence.
And at the time of closing argument, is it fair to say that Ms. Vander Ark was not assisting you? in your closing argument, given her mental or her physical state in the jail?
We had, before the day that morning, we had stopped talking about what we were doing in court, and it was just conversation of, will you come to court? That's all we talked about. Will you come to court? And when she couldn't, then we went back to court and we finished up. We had talked about the things I would say, generally speaking, during the course of my representation of her. But the reality is, a closing argument is as much art form as in science. I don't know exactly what I'm going to say every time, so I couldn't tell her exactly. She understood the plan. Did she know exactly what I was going to say? No, because I didn't know exactly what I was going to say.
But I want to just clarify, though, your decision to concede manslaughter wasn't an off-the-cuff decision.
Oh, no, it was not. No, it was not.
And you conducted some investigation and you put a lot of thought into doing that, correct?
Yes.
Okay. So I want to shift gears here into her competency. How many cases have you handled where someone has been referred for competency or criminal responsibility examinations?
3 or 4 a year, so 30 or 40.
Okay. And so have you had situations where you have somebody who absolutely can't assist you in any aspect of the court proceeding?
Yes.
Was that the case?
And if you are new to trials, it does kind of get confusing. So what does competency mean? And thank you, Wolfram, for your Modly Mod duties. Have a great lunch. So for competency for court, it basically means that you can usually read and write to a certain level. You know what day it is. Yes, there were videos and things that were not published. Now, I've seen them on some true crime channels because we had heard allusions to the video, the very last video where Timothy is alive, where Shanda goes in and stops him from breathing through it, agonal breathing through his mouth, calls him a dummy, closes his mouth, and tells him he can breathe through his nose. There are videos of those out there. I would not recommend watching them. They are heartbreaking. That young man didn't have comfort even in his final moments. He had the woman who gave birth to him calling him a moron as he's taking his final breaths. JKD Buck is right. Like, we do not hate this woman enough. It's just, I am shocked that this, to Velusa's point, I know a lot of attorneys that have started with state attorney or public defender's office, but never one for that many years. Those on defense side get overworked or totally disgusted with behavior. Yeah, I'm surprised that he's still trying to think of a benevolent way to reduce Shanda's responsibility, her culpability in all this. I am surprised, with as much as he's probably seen as a public defender, that he's still trying to find an outward locust or an outside of Shanda's control of what happened. It's amazing.
Case in this case?
No.
Okay. And during trial, was Ms. Vander Ark alert to her being Ms. Vander Ark?
Yes.
Was she alert to she was in Judge Casel's courtroom?
Yes.
And that it was the date and time that it was that year?
Yes.
Okay. And she was actively assisting you, it sounds like?
She was.
Okay. And was she assisting by writing notes while you were at counsel table?
Yes. And that was what I do is I can't listen to the witness chair and my client at the same time, so I give them a pad and pen and ask them to write notes and slide them over to me.
And without getting necessarily into what she was writing, was the content of what she was writing coherent?
Yes.
It was attuned to time and place?
Yes.
It was appropriate for what was going on in the courtroom?
Yes.
Okay. So let's talk about Thursday after she testified. Now, you don't recall if you went into the holding cell or the jail with her after the testimony concluded?
Okay, let's make sure I understand. When the trial was over, did I go into the jail? Okay.
Thank you for clarifying. That was a poorly worded question. When the proceedings on Thursday, not the last day, but the day she concluded her cross-examination,
Yes.
When that day concluded, did you go to the jail to meet with her?
I believe I saw her in the holding cell, which is back here behind the jury room. I think after each day, myself and the social worker involved, we go back and we talk to her for a few minutes, but then we break. That was the plan. Did it always happen every day? I don't remember. I think we did most days. I don't know if we did that day.
So you wouldn't be able to say how she was appearing outside of the courtroom after that?
I have no recollection of her. And after she walked.
I would guess just given his personality, he seems to be a very feelings-based person. He seems to be very much in the there is always a backstory into why the tabula rasa, the sort of, no one is born evil, situations cause people to have the mental issues that bring evil. My guess is that he went to check on her, he doesn't recall, but given the type of person he appears on the stand to be carrying, and the fact that he is still, even after Shanda is basically blaming him for being incompetent, he's still trying to find an excuse for her doing this magnitude of evil. My guess is that that type of personality, he would have gone and checked on her. But it's still at that point, she had finished direct and cross, so they didn't need her for redirect.
Out of the court that day, then I don't recall.
Okay. So let's move into that Friday morning
Yes,
that
ma'am.
you've already testified about. And you described that she was in a holding cell, correct?
Yes, ma'am.
Do you recall who was in the holding cell with you?
My Ms. Vanderark and my caseworker. Who's my caseworker? My social worker was there. I'm trying to remember which one it was. I don't remember which one it
Would it
was.
be Melinda Katecki?
Yes, that was Mona.
Do you remember a couple of jail deputies also being there?
They were in the area, but they weren't in the cell with us. There's a cell area, and they stand outside of that. They weren't in the cell with us.
Okay, so to your recollection, it was you, Ms. Katecki, and your client.
That's my recollection.
Okay. And you indicated that she was on the ground, curled up.
She was on the floor, curled up against the wall.
Okay. And could you tell the court what your conversation is with her, like at the start of that morning, when you first walked in? What's the conversation?
Are you okay? What's going on?
No, please tell me you said, "Calm the fuck down. Put your big girl panties on and let's get your atonement a startin'." 'Cause I'd be like, are you gonna cry or are you gonna come out here and be an adult?" This man is the right attorney for her because I would have had no chill. I would have had Excedrin. I'd have had a line of Excedrin, and I'd take one every couple hours just to annoy the crap out of her.
Can I get you something? What are you feeling? Can you explain to me what's going on? What was the situation? Ms. Gotecki was also talking to her the same sorts of questions. What's wrong?
And what did Ms. Vanderark reply?
Effectively, she
No idea, StreamYard. I have emptied out the cache. I have figured, I don't know. I've restarted my computer. I have done all the things that you have asked me to. I don't know. I don't know if it's the Shanda backup. Not that we want to see her face, but you know. Oh Lord, where did we have it? Shanda Vander Ark. Not that we want to watch her face, but that is what we said we were going to do.
Code, and she just couldn't tolerate being in the courtroom today.
And at some point you come up to the trial court and you place on the record
Yes.
what occurred, correct?
Yes.
And in that you stated you discussed Ms. Vander Ark's options, correct?
Yes.
Did you in fact discuss her options on how to proceed that morning?
Yes. Yes, ma'am.
Could you explain that conversation to the court?
We explained to her that option one was to come back into court and just sit there.
That the option was, I mean, we do have like the Lilliputians we have the Lollipop Guild with buckets of water or holy fire. That should have been her only option.
I'm not going to put you on the stand again today. Just sit there. Option two was for us to go back and ask the judge to adjourn. That was in fact plan A, to ask for an adjournment to give her, or at least some breathing spell. When this happened a time previously, the judge gave her 5 minutes, but we already had an hour or so in on this thing. So so that was plan B. Plan C was to continue to represent her. If the judge said go, we're going to go.
Did Ms. Vander Ark want the adjournment?
Yes.
Did she want, and if the adjournment wasn't available?
And people in hell want ice water. I don't see where, again, Shanda, if you wanted to be in a place in your life where anyone gave a shit about what you want, you wouldn't have taken your son's life.
I guess, did you discuss waiving her right to be present at court?
I don't think, I don't recall. I don't think I did. I don't think I told her that she had a right to refuse to come to court.
If she signed an affidavit saying that she is voluntarily choosing not to come to court, would that refresh your recollection?
It does. You're correct.
Okay.
That she did sign an affidavit.
Oh, I'm sorry. Liar says what, Shanda? Because there's kind of an affidavit, unless you're going to say that again, Shanda, here's what you don't understand. No one gives a shit enough about you to conspiracy against you. No one cares. Not many people can stomach looking directly at you long enough. It's like that, Vigo painting in, Ghostbusters 2. We're not quite sure why you're in the museum. You're the ugliest thing we've seen, but apparently in the olden days, someone made a picture of you. Like, yeah.
That effect.
Okay. And did you know that was happening, or were you aware that was something that was being drafted for her to sign?
Yes, I was.
Okay. And so does that refresh your recollection about the conversation?
Yes, it does.
Okay.
Yeah.
Now that your recollection's refreshed, do you recall explaining to her ability to waive her presence?
Yes, I remember. In the context of the affidavit, I think we came downstairs a couple times, and when we came down and said, "This is what's going to happen. You have this. If you don't want to be there, you have to let us know." And she signed an affidavit to that effect.
Did you coerce her in any way not to come to court?
No, ma'am.
Okay. Did you want her to come to court?
Yes, ma'am.
Would that have been better for your case if she came to court?
It would have been better.
Let's be real. Your case was probably better that the jury didn't see her visage. I mean, let's be real. No one seeing her face as the satanic Land O'Lakes butter girl was going to get her not guilty.
Yes, ma'am.
Did you feel like she understood what was happening to sign that affidavit,
Yes, ma'am.
or at least to make the choice to not come to court?
Yes, ma'am.
I apologize, I shuffled my notes here. Now, when you were asked about using the word competency, I believe it was on page 3 of that transcript you have there, you said, well, that's the word I used. Could you explain your response to that question?
I used it in the layman's vernacular as competency, not as in the legal standard as competency. I didn't mean that she, as lawyers know, that she couldn't participate or that she couldn't understand. I didn't mean it. I meant it as a layman would use the word competency. She just wasn't ready to go. She wasn't able to write me.
The state's attorney, so I believe she was present during the state's case in the original trial, but the male district attorney was more present. I don't think she even did any of the questioning, or she might have only done 1 or 2 witnesses. But she is a state's attorney, so basically this hearing is to see if there was any misconduct by her attorney. And it would behoove the state to have any input because the state might potentially, now I doubt that Shanda is actually going to get a retrial in this case, but if it turns out that there were some shenanigans with this lawyer, then the state might be looking at a retrial, so they get to ask questions as well because there is an interest in trying a case of this magnitude again. This is a hard case to try. This was a hard case for the jury. So I would imagine that having to do a retrial is not something the state wants to do. Neither do any of the family members of Timothy.
Those notes or this whisper in my ear or to participate as I would want her to have this. Her life's on the line. It's a murder trial. I want her to be fully able, I was going to say competent again, to participate in the process. This was her chance. This is her chance. And I didn't want her to leave that courtroom thinking that she left cards on the table or whatever the expression might be.
So it was not your impression that she was legally incompetent the morning of that Friday morning?
That is correct.
Now, had Ms. Vander Ark, and I know the court's referenced this before, but Ms. Vander Ark had episodes before, correct?
In my presence, she'd had, if we're not talking about when she saw the photograph, in my presence, she'd had 1 episode.
Yes, it was. I think I actually covered it. It was several years ago. It was, and I do think that alternate juror covered it as well. Um, the state did actually a good job, and the judge was very mindful of the images, only the images that were really, really needed to not overwhelm the jury. But it was a harrowing case. But I do think that if you're only going to watch part of the case, I would recommend you watching the state's cross of Shanda. She actually takes the stand, and you can tell that this prosecutor was ready to destroy her. And it's probably one of the better cross examinations of a very smart but not smart enough witness. Um, and you can tell that this attorney is having her stupidity. Uh, and that'll keep you from most of the horrible stuff in the trial. But if I was going to recommend you watch anything, it would be the state's cross of Shanda because they destroyed her.
But she expressed to me during the course of our representation that she'd had others.
Okay. And one of those episodes, and correct me if I'm wrong, but you observed the episode at the preliminary examination where her co-defendant was called to the stand and she had an episode, correct?
I don't remember the timing. She had the episode of the prelim.
Okay. And the record will speak for itself about
Yes,
when?
ma'am.
Okay. Shifting gears a little bit. Now, it wasn't your strategy to discuss hydration in depth, was it?
Was it my decision?
Dehydration and...
No, ma'am.
Why didn't you focus on dehydration?
It seemed to me that dehydration, along with the corporal punishments, along with the deprivation of food, along with all the other burdens that young man had to go through, were part and parcel of the same issue. Our argument was she did not form the intent to injure this child. So whether she injured him with dehydration, or she injured him by starving him, or she injured him by thermal, it wasn't an issue. The issue is, did she intend? Did she know? Did she create the intention in her mind to hurt this boy? And that was the issue. So I didn't concentrate on the other issues that the coroner said went into causing his death either, because they just weren't the issue I wanted this jury to come.
Shanda is also stating that she doesn't believe that Timothy died of dehydration, or at least it wasn't ever that she never limited liquids to her son. That she might have limited foods, but liquids were never limited. Now, I don't know how there are people that are incredibly smart but don't have any wisdom, because a smart person could tell you that yes, dehydration and malnutrition are two different things. But a person with wisdom is going to tell you that not a jury is going to really care a rat's ass whether you didn't feed or you didn't water your son and he ended up dead. They're going to think it's pretty evil regardless of the methodology.
Concentrate on.
Okay. So that was a conscientious choice on your part.
Sure, and we weren't arguing that the boy was dehydrated. We weren't arguing that he had passed away. That he was underfed. We weren't arguing any of that. We were arguing intention.
Do you think if you would have argued that he didn't have his water access restricted, that would have furthered your strategy at all? Or presented the case in a better light for you?
I think I would have lost the jury on that. They had photographs of this boy, and nobody's going to take a look at those pictures and say this boy needed water.
Yeah, this defense attorney is being very real. It's like when Darrell Brooks would look at the report and take a little miswording or something kind of colloquially used, a layman's term or something like that, and then try to make a molehill out of it, a mountain out of a molehill. There was no one, and I have seen the pictures and the video of Timothy's final moments, and there's no one who would watch that and say, well, I mean, she didn't restrict his water, so I'm sure she was okay.
There's been a claim that you provided deficient performance for allowing commentary in lieu of a video. Are you aware of the video that I'm mentioning?
Yes, the best thing I did in that trial was the best.
Yes, the video that they are talking about is the one I have seen. Now, Shanda had video or videotape equipment everywhere in the basement and in the closet where she forced Timothy to live. And his final moments were captured where he was agonally breathing after being in an ice bath at, I believe he weighed 67 pounds, or just some ridiculously low amount. If you've seen historical things that we shouldn't forget, that's what he looked like. And she shut his mouth and told him, look here, dummy, you don't have to breathe through your mouth, as he was dying. And Shanda is claiming that this lawyer not allowing that video in because Shanda tried to pretend that she couldn't remember that video. And the lawyer's like, I think we can stipulate to the fact that that video exists. Yeah, one of the better things he did as a defense attorney was stipulating.
Best thing that happened in that trial was the fact that that video didn't come in. That video is literally the worst thing I've ever seen. There is no commentary that can express to a jury how bad that video is. The commentary was by leaps and bounds better for our clients than showing that jury that video. I'm so pleased and grateful that the people did not push to admit it. That video is just awful. And to the day I die, that was the right strategy. It's the best thing we did during trial was keeping that video out. It is just awful. You'll never.
Right? I'm yelling at Mr. Mo. He is going to come and fix this stupid computer. I don't know what's wrong with Chrome. I guess I need to start using Firefox. Fine, I'll do that. But someone needs to figure out why the hell my computer keeps doing this, because it's like an expensive computer and it shouldn't be doing this.
That's what she said. Her response was that.
And I'm losing my daggone mind. I'm beginning to think I might have to. I don't know. It's only with Chrome, and I've cleared out the cache. I don't know. Maybe I've turned off my computer and updated it. So I do use Brave for my my new stuff. So maybe I'll just start to use it for everything. I have y'all. It's been a month. Y'all know I don't know what I'm doing when it comes to technology.
That she could no longer, she could not go up into the courtroom today. She couldn't take the trial today. She was having an episode, and she just couldn't tolerate being in the courtroom today.
And at some point you come up to the trial court and you place on the record what occurred, correct?
Yes.
And in that you stated you discussed Ms. Van Der Ark's options, correct?
Yes.
Did you in fact discuss her options on how to proceed that morning?
Yes. Yes, ma'am.
Could you explain that conversation to the court?
We explained to her that option one was to come back into court and just sit there. We don't have to put you on the stand again today. Just sit there. Option two was for us to go back and ask the judge to adjourn. That was in fact plan A, to ask for an adjournment to give her, or at least some breathing spell. When this happened a time previously, the judge gave her 5 minutes, but we already had an hour or so in on this thing. So that was plan B. Plan C.
At court.
Yes,
Your recollection of happening, or were you aware that that was something that was being drafted for her to sign?
Yes,
Now that your recollections.
Because we've already.
Was so prejudicial that nobody who saw it could unsee it and not give it and not absolutely close up. It's just it was, and given the weight of all the other information that Mr. Roberts had presented, it was duplicative, and therefore we shouldn't allow it in. That was my argument. Ultimately, as I recall, Mr. Roberts just agreed not to use it. We use this description, but we wouldn't use the actual video.
But that was due to a strategic stipulation, correct?
Yeah, that was big. That was one of the best things we did.
And it wasn't an oversight that you just let hearsay.
Oh no, ma'am. That was a relief.
And no, and he is not sugarcoating. He does not. He is if anything understating how incredibly fortunate for Shanda that the people, the state in this case, did not bring that video in. That I've seen the video. It's horrific.
I can just have one more. Thank you, Mr. Johnson. I have no further questions.
Thank you.
All right, Mr. Ambrose. Any follow-up?
You mentioned that the morning of December 15th, 2023, Ms. Van Der Ark was on the floor, curled up.
That's the day when she refused to, she declined to come to court? Is that what you're talking about, counsel?
Yes.
Yes, sir. That's how I found her.
And you did, you used the word competent, but you stated that you were using it to the court as part of a, in layman's terms rather than a legal definition.
That's correct.
Makes sense to me.
After the trial in this case, do you recall providing any interviews with the media?
I believe they were standing in the corridor,
Okay.
and I believe they did speak to me.
Do you recall telling, when asked the question about your,
Yes, he is newly assigned. I believe this is where, now I don't know if it's Shanda's idea or his idea, but I remember instantly not liking this appellate attorney because one of his first things to appeal on was the fact that the state did not prove that Shanda ever limited Timothy's his liquid intake so that dehydration, she wasn't found guilty of dehydration, therefore she should get a new trial as well. Um, it- he he really he's really struggling because I think that the defense attorney who's on the stand has done a really good job of explaining everything that happened in the trial and even things that may have looked a little bit kind of different or wonky, especially Shanda not showing up. I think he's explained it to a reasonable degree. And that's really all they have to do is the judge has to find that her former defense attorney's actions were not only reasonable but within the code of ethics and the rules, and I believe that they will find that, or that the judge will. This is a Hail Mary. I don't think it's going to work for Shanda, and I think her lawyer knows it.
your conversations with, or your interactions with Ms. Vander Ark, that she was in a catatonic state?
I may have used that term, yes.
Okay. And so that's kind of a serious situation, right?
Yes, sir, it is.
And that's more or less what you reported to the court, is that correct?
Catatonic state is a more egregious, is a higher level of incapacity than what I reported to the court, and that's what I report to the media.
Yeah, there was some testimony regarding dehydration, and it was your decision. Was it trial strategy that you did not use dehydration as a way to explain the death of Timothy?
Was it?
Okay, I don't know who needs to explain this to this lawyer and Shanda, but let me explain it to you. Not a jury in the mother effing world would look at the, you know, semi, survivor of the show of Showa, you know, pictures that Timothy had and think, gosh, that boy really looks dehydrated. No, they're going to remember every text message where you said, withhold what he's going to eat, make him throw up, put, bread with hot sauce in his mouth, don't give him food. No one is going to care that he was also found to be dehydrated. And you never, to your testimony, Shanda, should we believe you, you never limited his water. But you did think about putting really hot sauce on his penis, so I don't really give a rat's ass what you say you did and didn't do.
Yes, sir. The trial. Would you like me to answer your question? Yes. Okay. The trial strategy was not to try to explain. There was food in the house. There was water made available. The other children had corporal punishments as well. The decision was not to try to explain that these were causes of death. The decision was to explain that my client never intended this outcome.
Was there, to your understanding, was there any restriction on water
for
Timothy?
No.
And
Granny Smith, like a lot of parents who do resort to saying that their child was either, hoarding or stealing food, it's all about control. Usually the parents, with these kind of, malnourishment or neglect, um, honestly, Shanda kind of breaks the stereotype because usually the parents in these cases where a child starves to death, inevitably they're overweight, which is irony and just evil in and of itself. But she wanted control. Timothy being able to get food himself, I don't know. I don't know if she has disordered eating within herself that made, her not want to allow him to get fat. I don't know. There doesn't need to be an answer, though, maybe he did get into things. Maybe there legitimately were, issues with him eating to the point of being sick or something like that. But to limit his food to where he'd have to sneak to eat food, basically, at the end of the day, there was no logical reason for her to limit his food other than it hurt him, and she seemed to enjoy hurting him.
When's the last time you saw the death certificate?
I would have seen it before trial.
Okay.
That would have been the last time anyway.
May I approach the witness? All right. This was, it looks like it was People's Exhibit number 45 introduced at trial. Is that what you recall as being the death certificate?
I don't have any personal recollection, but this is the death certificate of the victim in this matter.
Okay, and what's the first thing that's listed
Okay.
as being the cause of death?
Okay. Cremation. What box is that in? Do you know?
36,
Okay, I was looking to that.
near the bottom.
Okay, 36. Dehydration and extreme emaciation.
Okay, and dehydration.
It's not or. So the dehydration, it's I don't believe it's like the ingredients on my Coke here, where, dehydration is going to be the highest factor and then starvation. No, they're kind of critically linked. So no one is going to look at Shanda and then again, as a logical functional lawyer who passed the bar on her first exam, and I do know that the bar does deal with some logic issues, you would think that she would realize that this sort of parsing of hairs, this kind of, well, he died of dehydration. No, they're linked, you moron.
Would be lack of fluids, right?
Yes, as far as I know.
And like you said, there was no restriction on water in the household.
That's what my understanding was. I wasn't in the household, so I don't know if it was or not, but that was my understanding.
All right, I have nothing for you.
Just a brief follow-up. So, Mr. Johnson, if you had focused on dehydration, would that open avenues to the prosecution to enhance some of their arguments?
I would assume.
Such as the fact that he didn't have access to water when he was locked in a closet, correct?
I didn't want to get into that.
Yeah, it's almost like there are reasons that maybe this lawyer was actually being quite strategic in not bringing this up. Almost like these are the things that you could have opened the door to, but let's continue because this prosecutor is going to get on a roll.
That he did have access to water in the ice baths, arguably.
That's what I was afraid he'd say.
And ultimately, and unfortunately, but by the defendant's actions, Timothy was so malnourished and unable to move that he could not get himself water. Would that be accurate?
I would assume that's at the end. I'm sure that's what the case was.
So there's multiple arguments and pitfalls if you were to take that strategy, correct?
If I would have attempted to argue that whatever in here did not cause a death, I opened the door for Mr. Roberts to show that, okay, it did, and that this was an issue. And I didn't want the jury to hear more of that. I want them to hear that my client just didn't get it. That was the message.
Thank you.
And your client still doesn't get it.
I know you're right.
Thank you. Mr. Johnson?
Sir.
I have some, well, it's a noon hour. Are you available this afternoon, Mr. Johnson?
Yes, sir.
All right. Let's break. We're going to Since we lost some time this morning, I'm going to have us return at 1 o'clock after lunch.
And we are going to speed right through. Wait a minute. Is that them actually coming back? Oh, furiously taking notes. No one cares, Shanda, really and genuinely. No one does.
All right, we're back on the record in 23-110 FC, People versus Shanda Vanderark. Where we left off, Mr. Johnson's understanding the parties had concluded their questions. The court did have some questions for Mr. Johnson. Mr. Johnson, you obviously know you're still on the road.
I do.
All right. Let me just see here. There were some questions by Mr. Ambrose regarding the suspension.
Yes, sir.
That I think occurred last year or this
I
year?
served it last year. It took almost 9 months to get the process rolling, so it actually occurred the year before.
All right. And my understanding, you've actually been here and again for hearing for that case, correct?
For that case, yes, but not for that issue.
You're not for that issue, but
This judge sees all the stuff. This judge needs to spill the tea. Like, what goes on in courtroom confidential?
but in this court, correct?
Yes, sir.
In this very courtroom, correct?
That is correct.
Okay, and that was for it was People versus LTJ Udall, is that correct?
Yes, sir.
And that was 2019, I think it's 947 FC.
Yes, sir.
All right. And I just wanted for the record, my understanding is the basis of the disciplinary action was that in that case, let me just go back. My understanding of the facts of that case, very briefly, Mr. Udall was charged with criminal sexual conduct, I think in the first degree. Is that correct?
Yes.
Okay. And the victim of that charge was a client or represented by the public defender's office. Is that correct?
Yes.
And that was in an abuse neglect case or an NA case, correct?
Yes.
All right. And my understanding, you did not actually handle that case, correct?
That is correct.
And was it other members of your office that had handled that?
Yes.
All right. And my understanding is there was a file that was taken from your office detailing this minor child's counseling records, psychological records. Is that correct?
Yes.
And my understanding is that you actually used those in Mr. Udall's defense.
I saw them. They weren't used.
They weren't used, but you certainly used them to prepare.
Yeah, yes, sir. I read them and I moved.
And my understanding is there was supposed to be you were supposed to isolate yourself from that. It was set up to isolate yourself from those files because you knew there could be a potential conflict. Is that correct?
Yes, sir. We had processes in place to make sure that didn't happen.
Okay. And that did not happen.
That's correct. The processes failed.
And so essentially you actually used what were supposed to be withheld from you.
Yes.
In that case, Mr. Udall's case. Is that
Yes,
correct? And that was the basis for the judiciary or the complaint, the
Yes, sir.
grievance, correct?
Yes, sir. It was.
And you admitted that this happened, and I don't think you contested it at all, correct?
That is correct.
All right. And that's the basis for the disciplinary action, as far as you know.
Yes, sir.
As far as you know, did the disciplinary action have anything to do with, not getting back to your client or not talking to her, doing something that you weren't supposed to do in terms of representation, something similar to what's being alleged in this case?
No, sir.
My understanding is that there was Mr. Udall's case actually had 2 trials. Is that correct?
Yes, sir.
All right. And you represented Mr. Udall in the first trial. Is that correct?
Yes.
And what was the result of that trial?
I was a hung jury judge.
Okay. And then the second trial, I have, at least according to what the records say, is they occurred in December 13th to December 15th of 2023. Is that your recollection?
Yes, sir.
Okay. Now, you had testified. Mr. Ambrose had asked you about, your stress level at that time. You're on a conveyor belt.
Mm-hmm.
Was that true at the time of the second trial in Mr. Udall's case? That you were on a conveyor belt? I think that's one of the reasons you said what was going on for the disciplinary action. Is that true?
Judge, it was that the workload continued unabated for the time I was at the public defender's office. It was self-inflicted. I didn't go on vacations. I didn't, when I retired, I had 50 more days of vacation time that they didn't compensate me for. I was at that office and I was doing that work. So yes, it was a continuation of the same process throughout the entire time. The only difference being was when it came to a capital, well, it's not capital in Michigan, but a life case in Michigan, the priority shifted so that the time that I needed for that case would shift to that big case, the life case, as opposed to misdemeanor cases that I might be working on.
And I actually misspoke. So my understanding, this trial, Ms. Vanderark's case actually took place between December 13th and December 15th of 2023. Is that your understanding?
Yes, sir.
I had it wrong. That Udall case happened in April of 2022. Is that your recollection?
I thought so. I thought his was done by the time Ms. Vanderark began.
Okay. So this trial,
Yeah.
Did you go right from the Udall case to focusing on Ms. Vander Ark's case? Because it looks like they went from April 2022 and then a little over a year later, you're trying another FC case.
No, I think there were at least a few weeks in between. I don't think so.
All right. Now, was there, looking back on it,
Yes, sir.
were you able to give Ms. Vander Ark's case what you felt was the appropriate amount of attention for an FC case?
Yes, sir.
Okay. All right. Was that with the assistance of the people you've already indicated?
Yes, the team did.
It wasn't all you, it was the team.
That's correct.
All right. And would you say that you were in charge of the team? Like,
Yes, sir.
you weren't absent and said, look, you guys do all the work, I got to take care of everything else. Or were you there for meetings? Were you there for other stuff?
I was there.
Okay. All right. And I'm trying to understand the defense strategy, okay?
Yes, sir.
From what you've testified to, my understanding is that your strategy was to essentially go from a intentional crime to a negligent crime. Is that correct?
In effect, yes, a crime where there wasn't the mens rea to commit harm. So yes, sir.
And honestly, that was probably the most that she was going to get. Had he been an extremely effective person and had she testified and been believable as not a swamp donkey from hell, then they could have got it down to maybe a manslaughter, maybe a neglect. But there's no way that you could see her in that video, that final video of Timothy, and say this was neglect.
At the break, I looked up the jury instructions, and it looks like you, correct me if I'm wrong, I can't remember exactly, but did you ask for the involuntary manslaughter instruction?
You did not.
You did not?
No, sir.
Okay. But it was included, correct?
Yes, sir.
All right. Was it at the request of the prosecution, do you recall?
Now that you mention it, I don't remember who asked for it. Now that you mention it, I don't know, because we obviously, for the record, we discussed these instructions in chambers, and the instruction, it would have come up. I don't know who asked for it. It might have been me. I don't remember.
Okay. So my question is this: you had testified at the beginning of Mr. Ambrose's questioning that Ms. Vander Ark had not given you consent to ask the jury for a manslaughter verdict.
That's correct.
Was that your testimony?
Yes, sir.
But then later on, you said the focus was going to be this is not an intentional crime; that there's just something wrong with it. Correct?
Yes, sir.
My question to you is: when these discussions between you and Ms. Vander Ark, did she unequivocally say, "I am not guilty of any crime"? Or was the discussions, look, I didn't do this intentionally. I didn't mean to do this. I'm not going to plead to something that I didn't intentionally do. Was there a dichotomy in that discussion?
The discussions about her responsibility came in two phases. The first phase, when we first met, she told me the same thing she told the police at the time that the boy was discovered, that she found him in the bunk bed, she put him down, and she's trying to administer.
Ma'am, there are video cameras. Like, who the hell? Do you think your lawyer is not going to look at discovery? Good night. I will be right back. Bio break. This woman is making me mad as hell. My bladder's not going to take it anymore.
CPR and et cetera, et cetera. That's the first thing she told me. Then after that, once we got past that and the police reports came in, it was clear that was the situation. We talked about individual defenses to individual crimes. And we covered everything. We covered all the things that she might be, that her conduct might find, the jury might find her guilty of. I never directly challenged her, did you do something here? And that's not my way. The client either wants to talk to you about that way or they don't want to. But based on the conduct of our conversations, it was clear that she was aware that there's something that's wrong here and there's something that I may be found guilty of. And that's kind of how we kind of, in order to bridge the gap from her having to confess to me, we kind of discussed it as there's something you might be found guilty of. And this is the things you might be found guilty of. And this is the things that we might be able to achieve if we do these sorts of things. And avoiding, and the bottom line is avoid first degree murder.
Okay. So it was never, she never said, well, I'm guilty of something. It was more of discussion about, okay, throw it all out the window. What could the jury eventually find? What's a mitigating thing we can do? Is that right?
That was the strategy, Judge. It was never, I never confronted her to ask her if she did something wrong or not. I gave her the way out. The jury might find me guilty of these things. What are we talking about? And that's how we bridge that gap.
So there was never an affirmation on her part that I recognize that I am guilty of a.
Okay, Shanda, you might not recognize that you're guilty, but let's be real. You are the only person on earth that's like, I'm all the innocent. He could have all the water he wanted. Again, I don't know where in the Delulu you think you're gonna find a jury that's gonna be like, "Oh, he could drink from the ice water in the bath? Oh, well, you're innocent, Shanda. Go ahead. Go on out of here. Get on out of here."
Not unintentional type of charge.
Never before or since.
And it sounds like initially you wanted to find an expert witness to assist you in that defense, correct?
Very much so.
And you went through, you tried 2 different expert witnesses, is that correct?
We hired 2 different ones. We talked to 3 or 4 others, and we talked to other people, but we hired 2.
Right. And is it your testimony you could not find an expert that could assist you in that defense?
Yes, sir. That is my testimony.
Yeah.
Did you discuss with Ms. Van der Ark that you were going to make the argument to the jury that she was guilty of an unintentional, negligent type version of either manslaughter or homicide? Did you ever discuss that with her, that was the strategy?
I can tell you how we discussed it. First-degree murder is an intentional homicide. You didn't intend to do anything, and that's the argument we're going to make to the jury. That's how we discussed it.
Did she ever say, wait a minute, no, I don't want you to do that because I'm not guilty of anything here?
No, this
Jen, so her adult son, she has 5 children, or maybe 6, with, let's see, her ex-husband, I think his last name was Ferguson. She had either 4 or 5 children. Timothy was the youngest of that bunch. She then moved, she lost custody of all of those children, and technically shouldn't have had shouldn't have had custody of Timothy when he died. But the older brother, another son from that first marriage, Paul, actually does share, co-defendant status with her because he was kind of the muscle. Shanda was the mastermind, but Paul was definitely the muscle that kept Shanda's wicked games and punishments going when she couldn't be home.
And again, she was the client from heaven. She sat and she listened to me talk. She understood, and then she trusted my judgment. At least her conduct indicated she trusted my judgment from that second week on. The only thing we ever had a crossword on was about the Michigan-Alabama football games.
So again, she never said, Mr. Johnson, that is not an argument I want to make. I am maintaining my innocence to every single thing, that I am innocent, and I absolutely do not want you to concede any sort of guilt in any way, shape, or form.
That is absolutely correct.
Okay, that she did not.
She did not. Not ever.
And you feel, coming from a defense background, sometimes defense attorneys have a tendency to they think they know more. They know what's better for the client, right?
Yes, sir.
I know you don't want to do this, but we're going to do it anyway because I want to make sure that we're successful here.
Yes, sir.
Did you do something that she did not want you to do to be successful, or did you do what you had to do in consultation with her about what the strategy was going to be?
The latter. And again, this is a different client than what we normally receive. This is a client who's much more sophisticated about the law and had much better understanding. And our relationship was more co-counsel, or maybe senior counsel myself and junior counsel, but more co-counsel than lawyer layman or layperson. She understood the strategy. She conceded that was the strategy that we were going to use at trial. She understood it. She knew I was going to do that. Did she know the exact wording or how it would come out? No, she didn't, because I didn't. But she understood it, and she understood what we were going with. And at no time did she express concerns that I don't want to do it that way. I want to go and say I didn't do anything else, and whatever her argument would have been. But no, I never asked her if she committed the offense. She never told me she didn't commit the offense.
The other question I have is, in all these discussions, obviously you're saying not first degree, not premeditated.
Yes, sir.
Not second degree, not because that's an intentional crime,
Yes.
right? Not necessarily voluntary manslaughter,
Yes.
but was there ever discussion? Well, listen, this is the charge. We think. Let me back this up.
Okay.
You had said you argued to the jury manslaughter because you were hoping that they would find a middle ground and go for second.
Yes.
Was that the strategy that you guys came up with? Or was that kind of like in your mind, you said, well, wait a minute, worst case scenario, maybe it'll be second, but I really want manslaughter?
Okay, no, this is a strategy that I came up with. We did not come up with it. This is the strategy that I suggested to her, and I told her I was going to follow. And at no point did she express to me that, no, I don't want to do it that way.
When that final day when it was last day of trial, you indicated she was in a ball in the holding cell. Did you ever suggest doing Zoom, potentially? Her zooming in from outside the courtroom for the trial?
No, I did not.
Okay. Did you feel rushed at all that morning by either myself or the court or anybody else to kind of say, let's get this rolling? And
not rushed. I wish we had adjourned it for another day to see if she could come around, but no, I didn't feel rushed. I understood that the issues were presented to the court. The court made its call. It wasn't that the court was trying to rush me to do something. It's just that this is what the court thinks is we're going to do. So that's what we do. I didn't feel rushed. I just felt, okay.
We did. I think we waited a couple hours, correct?
Yes, sir.
And now I want to make sure. I mean, you're obviously aware of the legal definition of competency in terms of state of Michigan.
Yes, sir.
Can she rationally assist in her defense? Does she understand your job, prosecutor's job, the court's job, the jury's job? Do you feel that she was legally, according to the standard of the state of Michigan,
Right.
would you believe that she was legally competent in everything that you observed that day?
Yes, sir.
Did she ever say, hey, listen, I want you to ask these certain questions?
No, sir. She directed me to ask very few questions. She had observations, but she didn't.
I'm talking about that day.
Oh, that day. No, sir.
I think her affidavit says she had a lot of questions that she wanted to ask the witness. I think I'm paraphrasing. I'm just wondering if those were ever communicated to you when she was in that state.
I want to watch it. I haven't watched it yet. I think that one is on Amazon. I need to watch it. Yeah, she is very, very worried only about justice to her own or to herself. And it's very telling that as a mother, she lost custody of her children. It is very rare that court systems will take a mother away from their children. Again, the fact that she, signed over her rights and that was recommended, that is not usual. So there were legitimate and documented accusations of her injuring not only Timothy, but her other children to the point that Oklahoma, I believe, was the state that she had lived in, asked her to relinquish her parental rights, or they were going to go after her for all of these things that she had done to her children.
Yes, sir.
Okay. All right. That's all I have. All right. Any follow-up, Mr. Andrews?
Yes.
Go ahead.
It was your request, the lesser included. Is that correct?
Probably. It was a chambers discussion when we talked about the instructions, and so I don't have any specific recollection, but probably I can't think the people want that instruction.
Okay. May I approach you?
You may.
And this is a transcript of December 15th, 2023. Page 41 near the bottom, and you can go to the next page.
Okay.
Does that refresh your recollection that it was your desire, your request for the involuntary manslaughter instruction?
To be honest, counsel, I still don't remember asking for it, but I don't have any reason to dispute what's written there in the transcript.
And it does say that Mr. Chambers, or Mr. Johnson is your, so my understanding from our discussion in chambers, Mr. Johnson, is you're requesting an instruction on lesser included offense of involuntary manslaughter. Is that correct? And your response was, that is correct, Judge.
Okay.
All right.
Yes, sir.
I agree with that. So it was your request.
Clearly.
And so my client's, Ms. Van Der Ark is not in the courtroom at this time, correct? December, that's that Friday.
If that same day?
Yes.
No, she's not in the courtroom.
And you're not discussing involuntary manslaughter with her when she's balled up on the floor, right?
Now, I will say that I have gone through all of the publicly available records, and at no point, either on any true crime genre or any true crime channel or any other area that I've looked has Mr. Ferguson or Timothy's biological father ever said anything publicly about this case. He didn't want to say anything at victim's impact. So I try not to judge that maybe he wasn't as impacted. I would hope that it eats him up that he sent his son to an unsafe place, but given that the the childhood was very chaotic, I don't know if the father was part of the chaos of the childhood as well.
That's correct.
And she's catatonic, right? Is what you said.
It's what I said to the press, sir. She was distraught, and she was literally curled up in a ball and crying on the floor.
And you're not discussing with her at that time, or are you? Hey, I think I can go with the involuntary manslaughter. What do you think?
Correct.
All right. And throughout, from day one, Ms. Vander Ark said that she was not guilty of this offense. She maintained her innocence. Is that correct?
As I've said, I never asked her if she did it, and I don't recall her saying, I didn't do this. There's quite literally videotape of her conduct. So I don't recall her ever saying, I didn't do anything. What I recall is she never told me that she intentionally did anything to her child, or to any of her children. And that's what I...
RJ, did they ever verify if the rumors of Paul S.A.ing his little brother back in their former state? I've seen allusions to it. I've seen allusions more, though, towards the people who have looked into that, and I think it was This Is Monsters. He has a really good radio voice. I don't share all of his opinions, but he does really good research, and I think he did a This Is Monsters episode about her. And I do believe that Shanda, there were allegations of Shanda watching the children when they were in the restroom and things like that, inappropriate nursing older children, nursing topless in front of her kids. So I don't know if of the allegations specifically with Paul, but I do know that there were allegations, at least allusions towards Shanda being inappropriate with the children. I haven't personally looked at it, and I'm sure most of that is kept back, obviously, because there are adult children who have probably been mentioned in those records. But as far as I know from what I've looked at, I only remember there being allusions to Shanda. And I do find it odd that she spontaneously came up with, um, you know, Timothy needing to have hot sauce on his private area. I find it very odd that a lot of her punishments involved him being nude. Um, so I, I I do think that there was an element of either humiliation or degradation. Now, Shanda has said that she experienced that in her own childhood, but that's coming from Shanda, so I don't know. Yeah. I feel horrible. What I will say is if you wanna see something that's both heartbreaking, but it will make you feel good that 2 of the children that were subjected to Shanda have turned into incredible human beings. The victim impact statements, from Timothy's oldest brother and his only sister, are 2 of the most incredibly brave and amazing, victim impact statements that I've seen, and those 2 are shining examples of having a crappy childhood and going on to be a good person in spite of it, not using it as an excuse to get away with horrid, horrid behavior.
I don't recall her saying, I'm not guilty, this is not me, I didn't starve my child, that sort of thing.
Did you guys ever have a discussion? Ms. Vander Ark, you kind of meet these elements of involuntary manslaughter. You want me to see what I can do with the prosecutor, see if they'll accept a plea?
Sort of. What we talked about was she's charged with this homicide, and these are the possible outcomes a jury could legally come to, and these are what they require, and it may be and we talked about it. If we're winning the trial, what do we do? If the trial's not going sideways, what do we do? That sort of thing. But she understood that there were options, and that, and during my conversations with her, that we talked about what we might argue on if the facts support it. Does that make sense?
Well, you mentioned on direct in the morning, it was kind of your decision to argue to the jury that she's guilty of involuntary manslaughter.
That's correct.
My client, Mrs. Vander Ark, never said, I'm guilty of voluntary manslaughter.
That's correct.
And just as a general question, on December 15th, when
Wait a minute. What the hell is Ponytail Esquire III doing out of New Jersey? Sir, we see you. Michigan cannot handle another ridiculous defense attorney. Tristan Ponytail Esquire III, you get the hell back to New Jersey.
was, on the floor and in distress, did you request any type of medical assistance or to have her evaluated?
No, sir.
Your Honor, I don't have any.
Shanda.
I don't have any further questions.
I don't think so.
Just a couple briefly. And Your Honor, I guess I would just ask the court at this point in time to take judicial notice of the opinion and order regarding new trial in the LTJ Udell case. I do have extra copies. I wasn't anticipating admitting it, but given the court's questions, I think it's just come up. There's been a Ginther hearing. This is the court's ultimate opinion on the matter. So I just asked the court to take judicial notice. And I do have a copy for admission if the court wants it that way versus.
Yeah, that's fine. I think I can take judicial notice of it, right, if you're asking, because it's in the file, so.
I would just mark it as people's too, or proposed to.
All right.
So basically, for if you're coming in, this defense attorney was kind of the head defense attorney for Muskegon County. Apparently, he, while there were, procedures and safeguards in place, he went and used some information that was kind of safeguarded for a victim of a crime for a defendant of the crime. So he did admit to wrongdoing and did get a complaint and a suspension. However, what the prosecutor is bringing now is basically what the court made after, what the court decided to do after Mr. Johnson, the defense attorney, made the admission that he had taken some of those records inappropriately. He did have a 6-month suspension. I do not think he is the prosecutor now. So yes, he did admit to it, but in Shanda's case particularly, I think he did an okay job with what he had.
Mr. Ambrose? Any objection?
No. Court record.
Thank you. Do we have exhibit 1 too, by the way? This is still on the
It is.
Is it needed anymore? Or I'm just gonna make sure I keep track of the exhibits, so. All right, good enough.
Mr. Johnson, is it? I'm sorry, Your Honor, may I proceed?
Oh, so this is the opinion or an LTJ Udell case, correct?
Correct.
Okay, all right, I wasn't, Mr. Ambrose, were you aware of that?
Yeah, I mean,
I wanted to make sure we're on the same page.
Yeah.
Okay, yep, I remember it. So wrote it. So, good enough, go ahead.
Just to confirm, it's been admitted.
It is, yes.
Mr. Johnson, is it fair to say that you're aware that involuntary manslaughter is a necessary lesser included offense to murder?
Yes, ma'am.
Okay. So if the record shows that you requested it, would that be a standard course and an open murder charge to ask for that?
Most certainly.
And you did in fact go over involuntary.
Also, to not forego our hair and fashion, I very much love this suit on her. I would consider her curvy, but I think that this is an excellent suit. It's not too boxy. It's not too clingy. It does emphasize her chesticular region. Generally, when you're curvy, you are going to have a chesticular region, but it's not, tits out for, Vegas. I think it's a lovely outfit. I am just proud that she's, she's walking around in high heels better than I ever could. And her hair looks incredible. So I think all in all, it's a nice fashion hit instead of a miss with Miss Kathy Nestor slaughtering love seats and pillows.
Manslaughter and what that would entail with your client.
On multiple occasions.
Okay. And so it's not that she's in the jail, she's away from you, and you just decide to ask for the instruction right then and there without consulting her.
Well, I didn't ask her if we could put in the instructions, but we talked about that argument being an option.
Did she condone that option?
She doesn't do that. She doesn't say, okay, you got it, I will do it that way. She simply, I tell her this is what I think we should do, and she nods yes, and okay, and that sort of thing. She's not the kind of person who is going to challenge, I think. She understands and she trusts.
Did you feel that she was aware about the strategy about attacking the mens rea elements?
Yes, ma'am.
And based on your knowledge, mens rea is different for first degree, second degree, and manslaughter, correct?
Based on my knowledge, yes.
So while you might not have used the words manslaughter, was she aware that there was going to be some concession of mens rea in some way?
Okay.
Maybe negligence or something along those lines?
And we discussed options prior to trial, and I told her what the options were, and that as depending how the evidence came in, we would select one of the options. One of the options I told her that I would be selecting.
Ma'am, I hope you run your mouth to someone and they, you know what, you think you are in charge. Thank you so much, Tammy Fayette. You brighten my day. Well, I decided to get all my rage out before I went to the dentist. I don't know why I do this to myself. I really should go to one of those sedation dentists, but I have to also take the Ferrol, so yeah, she's trying to push that her defense counsel in her first trial was all the bad. I mean, if you listen to what she's saying, versus what her very competent sounding defense attorney did. It's almost like Shanda doesn't tell the truth.
Be this negligent homicide argument. So did we sit at the table and talk about it during the trial? We did not. But she was aware that was an option, and she was aware I was considering it, and she never objected to it.
Thank you.
Mr. Ambrose.
Oh, making notes. No one cares, Shanda.
And her testimony at trial, would you agree, was an expression of her being not guilty?
Yes.
Her belief.
Her testimony at trial was an expression of her belief she wasn't guilty. No, she feigned a hysterical illness. It went so bad. I think that she perceived correctly how terrible she looked on stand, and that's why she pretended to be catatonic.
That she was not guilty of anything.
Yes.
I don't have any further questions.
Can I help you there?
No, thank you.
All right. Mr. Johnson, I just want to clear, I think we're all dancing around the same question here. Did you ever say, hey, listen, I'm going to, to her, in those words, we're going to go for involuntary manslaughter?
No.
When you said possible outcomes, did you mean, hey, listen, open murder, you can be first, second, voluntary, involuntary? Is that what you discussed with her?
That's what we discussed.
Okay, and did you discuss all the elements of all those?
Yes, we did.
Okay, and it sounds like you discussed 1 and 2 are off the board, correct? I mean, that was not something you guys were going to argue, correct? First and second degree?
No, certainly not.
Okay, and when you guys talked about, so my understanding is as the trial progressed, you were waiting to see how the proofs came in, to see exactly what manslaughter was going to be argued or just complete. I mean, did you ever foreclose the idea of the argument to the jury that completely not guilty of everything?
No, sir, that's the first argument.
Okay. And then was it, okay, listen, depending on how things go, then we might have to say, all right, well, that's out the window. Maybe we should argue involuntary manslaughter.
Yes.
Right. When you guys discussed this, did you use those terms, involuntary manslaughter?
Yes, by name.
So you actually said involuntary manslaughter to her?
Yes.
And you believe she understood that?
Yes, both manslaughter by name. She's a lawyer. She understood. So I wasn't as reticent about not But by breaking it down as I normally would be, she understood all four, the options, and we talked to them by name.
Okay. When did it become apparent to you?
Yeah, and her personality type, see, Shanda is very, very blind to what she appears like, but even a casual observer would realize that Shanda is the type A controlling personality that would demand he goes over exactly what he means by everything, that they have the same definitions of things. She would not let nuance, I think, go. As much as he says that she was a star client, I think she was very exacting, very precise, and very controlling about the strategy she wanted. So I don't know if he's trying to whitewash her at for some reason, but at this point, this would be time to say she was a bitchy client. Like, look, I didn't want to go in there. She was always telling me. I believe she performed exactly like Sarah Boone with the self control, a modicum of self control that allowed her to become a lawyer. But she's delusional if she thinks that anyone as a defense was going to be able to argue completely not guilty with a straight face at closing arguments with everything the state brought in.
In the course of the trial, that the complete innocent verdict was gone. The fact that you were going to go for not guilty completely. That you said strategy number one. When did that occur to you that that went out the window?
Judge, if you will recall, there was a point in the trial where the witness testified that he sent my client a photograph on his phone of Timothy, and he was shirtless, and the pants were falling off of him.
Now, I will say, like I said earlier, if you do go back to watch this case, and really you only need to see Shanda's cross-examination by the state, but the judge and the state did a very good job of not continuously showing these pictures, and they absolutely could. They could have pulled on the jury's heartstrings. I have personally seen the picture that they worked very diligently to keep out of the press. It is heartbreaking. Again, you have seen people like this getting released from Bergen-Belsen and Treblinka and Ravensbrück. I mean, that's what he looked like. Anyone, even very, very stupid people, could understand that that Timothy was being starved or didn't have food. Something was preventing him from gaining weight. If you had seen him just generally walking down the street without a shirt on, you would have called someone, because there's people who are naturally thin who, get the sort of like eat a sandwich. That wasn't this. This was obvious that there was something wrong. So you would have to be blind, deaf, and dumb to not notice what was going on to this child.
And he sent this photograph to my client, and my client saw it and responded to it. At that point, given that it became clear to me to tell this jury that there is no guilt here, was not going to be an effective argument for this client.
Was that discussed with Ms. Vanderark?
Specifically, no, not that specific.
After that day, did you say, hey, listen, option one's off the board, we're going to have to go with option two?
No, sir.
At any point in time was it discussed?
No, no, I did not. I would assume that had she been here, we may have, but that's just an assumption. I don't know. But certainly the decisions that were being made during trial, whether or not she was going to testify or not, that was done at the point when it became obvious that it might help her. But matter of fact, that's the other decision that was made when that picture came in, that she's going to have to testify. But no, there wasn't a sit down discussion saying, hey, we're gonna go for involuntary manslaughter here. That did not happen.
Were there previous discussions that at some point that could happen, that you'd have to one was off the board, you have to move on to option two?
You mean
with Ms. Vanderark?
Yes, that was discussed. Yes, that was discussed along with, and I reviewed the file, I knew it was in it, along with the likelihood that not guilty was not likely here, that we would probably be doing something to make sure you don't spend the rest of your life in prison.
When the option of involuntary manslaughter came up in all these discussions, was it ever expressed by Ms. Vanderark? Absolutely not. I'm innocent.
No.
All right. Sorry to open the door again, Mr. Ambrose. Any other questions?
Yes, I mean, okay, so during the whole trial, you hear all the prosecution's case, right?
Yes, sir.
And in the trial, you make a decision or you discuss with Ms. Vander Ark that it's probably in her best interest to testify, right?
Yes, sir.
And that occurs when this photograph shows up or appears. That was a reason to have her testify, or is that?
Yeah, there was as you know, with trials, the information accumulates, and when that piece came in, that
Now, during your questioning of Ms. Vander Ark, do you ever ask her, Ms. Vander Ark, it sounds to me like you committed some sort of crime?
did I say that? No.
Yeah. And you never asked her on direct examination, well, don't you think you know, they have a case here for involuntary manslaughter? Do you ever ask her anything like that during the trial?
No.
And I think on direct examination, you kind of said that it was your argument to make to the jury that she was.
It's very odd to see her mask slip. I bet that she constantly disagreed with the opinions of everyone. She's definitely the type of person that probably in all situations thinks that she knows better and could have crafted or thought of something better. So it is amazing to watch how much of her self-control is gone. She's obviously deemed everyone at the prison not worth, showing her, respectable side to. So she's gotten out of the habit of not showing on her face what she believes and her contempt for literally everyone, but mostly for her child. I mean, she still, I honestly believe, blames Timothy for his death and getting her in trouble. My guess is she curses Timothy every day. Like, if he had just paid attention and listened, I wouldn't be here. She has not taken an ounce of responsibility, and she never will until Satan meets her at them fiery gates.
Guilty of involuntary manslaughter.
Yes.
And yeah, I have nothing further.
One question.
Just very briefly.
Mhm.
She wasn't convicted of manslaughter, was she?
No.
So the jury rejected your concession anyway.
Yes.
So there's no, well, never mind. I have no further questions.
Any follow-up to that, Mr. Ambrose?
I'm through.
All right, good enough. May this witness stand down, Mr. Ambrose.
What's that?
May you be excused.
Yes, thank you, Mr. Johnson.
Some questions? All right, thank you, Mr. Johnson.
Thank you.
All right, excused. All right, Mr. Ambrose, you can call your next witness.
I will call Shanda Vander Ark.
Ms. Vander Ark, if you want to come on around,
Oh God, why?
please remain standing and raise your right hand and be sworn as best you can.
Faster.
This matter now pending. Do you swear or affirm the testimony you're about to give be the truth?
I thought her head was just a pounding and she damn near sprinted to that. She wants to talk. Unfortunately for her defense, she wants to talk.
With the whole truth and nothing but the truth, so help you God. I do. All right, put your hand down and grab a seat. Please state your name for the.
Ma'am, you are aware that the Lord is listening and you could be struck by lightning. You have not even ever been in the zip code of 15 miles away from the truth.
Record, spelling your first name and last name.
Shanda Vander Ark, Shanda, Vander, space capital ARK.
All right, go ahead, Mr. Ambrose.
First, Best Gigi, she is wanting a new trial.
Ms. Vander Ark, you heard well, first off, your medical condition. Let's just briefly go through that. How's your condition right now?
I'm miserable. I'm
Glad to hear it. Please explain in great detail how you are suffering, because I need to hear it. Actually, it will make my heart grow fat, like 3 sizes, like the Grinch. It will actually help my day to hear your suffering. So please, I never thought I was sadistic. I always thought I was a masochist, but I am finding a sadistic bent right now. So explain in excruciating detail exactly how much you're hurting right now. Make it sexy for me.
lightheaded. My head is just splitting. The back of my neck hurts constantly. It's something that goes along with the thyroid issue, I guess. I've been shaking. This is almost constant now. It started a couple days a week for a few hours at a time, and it's almost constant now.
Would it be your preference to testify at another time?
Absolutely. I feel like garbage.
With that, Your Honor, I would.
But as a swamp donkey and literal human garbage, it is kind of method acting.
Renew my request for an adjournment.
I have a sidebar with the attorneys real quick?
Don't cry for her, Argentina. The truth is no one gives a shit. I hope she has a splitting headache. I hope her migraine never ends.
We're back on the record in People versus Vandark. Ms. Vandark, you can stand down. You can go sit next to your attorney. This is, as a practical matter, it's 1:49 p.m. The people indicate they have 3 witnesses they wish to call. Mr. Ambrose obviously prefers his client be in a better medical condition. Quite frankly, this is likely to go on past today anyway. So because of that, there's really no point right now in pushing her testimony forward right now. She's not feeling well. I think the parties, and correct me if I'm wrong, agreeing. Mr. Ambrose, you don't have any objection to the prosecution at this point in time calling her witnesses out of order. That way we can come back here from Ms. Vandark. Is that true?
That is true.
Anything, Ms. Bloomquist?
I'll leave it on the court's discretion, but I'm ready to proceed with my witnesses.
Okay, well, let's do that. So, Ms. Bloomquist, you can call your first
The
witness.
people call Melinda Pateki.
And unfortunately, we are going to have to finish this little bit probably tonight, unless we go into a second day, because I have to pick up the youngest, most feral. We have dental appointments, so hopefully, I won't be numbed out, and I can actually finish up this stream and get Brave as my server, because apparently Chrome hates me. So I do apologize. I thought we would get through it. I didn't realize there would be, um, as much waffling and whining as there was. Uh, but it does look like we will have state's witnesses, and um, if we don't get through it today, we will finish up this last little appendix of this tomorrow and then get started on the opening statements for the Hawaii dentist attempted murder trial. Again, that one, I know we will be way behind and we probably won't finish before there's a verdict. But that trial is a bit crazy. We have a live witness or a live victim who is going to be testifying. And the defense in that case, according to people who are watching it currently, are of the same ilk of Shanda. They want to make the guy who beat the tar out of his wife the victim because she apparently was having an emotional affair. I do not know when we get the quadruple amputee, but I will definitely check out because we will be following that trial from the first hearing, from the very tippy toe, going directly to hell. Let me see who I can send you guys to, since Baker is really good at remembering to do this, and I am terrible, so I'm trying to be better. All right. Well, I'm going to send you over to it looks like, I'm gonna send you over to Dolly. It looks like he's doing, court feed, for Judge Fleischer, because everyone else is on verdict watch for it looks like, the antifreeze case, so everyone else is on that. Uh, Interesting, interesting. Have a wonderful, wonderful day, you guys. I will be back this evening if I am not numbed up or the young feral isn't numbed up. Because if any teeth need to be anything done to them, um, we are not okay. Youngest most feral is a pain in the behind when he has to get teeth work done, and I'm really not much better. So, um, hopefully we'll get back and I'll be able to do the last little bit of this hearing. But if not, we will finish it tomorrow and then get on to those opening statements because that trial is looking interesting and not a lot of people have been covering that one. I think I've only seen Ada K covering that. So I figure that will be an interesting trial for us to cover. And then I think we've got some big ones coming up soon. We should be fine. This is really only for a cleaning, but I know youngest most feral's ability to brush his teeth and his actual brushing of his teeth record, which is somewhat good if I stalk him like a freaking vampire. Um, So, uh, so we will be okay. It's more the sound that gets me. Oh, for the love of Cheetos, it's the camera's gonna go again. All right, I'm letting you guys go while I figure out how to switch Brave to my browser and not Chrome. Bye, you guys.